Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
Now we're getting commentary on the case.
Literally not true.
Dahil mihi Anglican po.
Is that correct?
I didn't ask you to interrupt me. Oh, for crumb's sake.
Scratch all that. Oh, that was terrible. I apologize.
Good morning, good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Wow, and that was really loud. Sorry, my voice was cranked up there. All right, I'm back. Happy Monday to you. To everybody except, come on. There we go. Greeners who won the internet. He has got his work cut out for him today. And, Greeners, keep it all running. Why can I not see? I need to go up higher. What? There we go. I found the button. All right, there we go. Now I can see. Welcome. Great to have you here. We've got some stuff to watch today for sure. A big thank you to everyone who popped over on Runkle's stream on Saturday. I was able to join just for a little bit. It was amazing to be with some absolutely incredible people from the world of LawTube and beyond. Great purpose that everyone united there for. And last I checked, Ian had a goal of $100,000, and he's at 97,000. I don't know. 942 or something like that. It's way up there, and it's still going up because there's still some residual coming in. So there's a good chance that he will, in fact, hit that 100,000 by the time this all closes. And it was awesome. It was absolutely awesome. Some great people over there, just all over the place, popping in, showing up, and even Nate the lawyer, who literally joined chat from his hospital bed where he's about to undergo brain surgery to remove a tumor, joined to say some great words and encourage the effort. So thoughts and prayers for Nate the lawyer right now as he's going through that surgery, which they say they're optimistic about, so they're looking forward to that. So surgery was supposed to be yesterday, got put off. So I think it's happening actually right now. They had some problems with the MRI machine. Kurt from Uncivil Law went in, visited, and posted a selfie there that Nate asked him to post. And a lot of positive energy there from Nate. So he's hoping that his hair doesn't get cut off. He's hoping he gets to keep that. But if not, he'll grow it out again. Anyway, welcome and thank you all. Thank you all for being here. It is absolutely wonderful to be here. There are worse places to be, of course, and our thoughts and prayers with those people who are in a situation like that beyond their control. And then there's also court. You could be there, and we could be there too. But give us a minute. We'll join in just a minute. We've got a few things going on today that we might be able to pop in on, one of which we'll play a tiny bit of catch up on right now. Because the Brian Walshe hearing is just beginning, and we want to see what happens there. We'll bring you all of that. Don't worry. That case, they're starting jury selection this week, but the trial itself, we shouldn't hear any evidence until the 1st of December. So we've got a couple weeks before that one starts. We will be there for that. And Runkle did a great job. Yes, absolutely amazing. I saw many of you out there bidding and supporting the effort, and some just donating, without anything to bid on, just a couple dollars here and there. It added up very fast, and it's amazing. All right. Speaking of somebody needing prayer, Bug Duggar needing some prayers this morning. Mr. Bug having surgery in an hour. He's okay. He just has some stuff that needs work. Bug Duggar, thank you very much for sharing that. I'm sure we've got a lot of people who would love to throw a little support your way in the prayer department, and we'll do that for sure. Let's see. Let's see, where else do we have? I think, do we have any birthdays today? I know we have birthdays somewhere. Did I miss any? I don't think they've been posted yet. But we do need to sing. Oh, Kelly H., thank you very much for the super sticker. I love it. Thank you very much. What a great start to the day. Yep, I did not miss the birthdays, I'm pretty sure. So any moment now, we'll get an update. There we go. Thank you, Red Pen, for that. And I'm not sure if he wants a shout out or not. Josh is feeling under the weather, so I'm not sure if he's going to pop in or not. But be mindful of him. He's got a little bug that's going around, and that's never fun. So Josh, get feeling better. Greg on Sports, Penelope, Sunshine, and Tammy Lynn have birthdays today. So join with me, everybody. Stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with a neighbor, warm up with me if you will. La 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 la. We're ready. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Greg on Sports, Penelope, Sunshine, and Tammy Lynn. Happy birthday to you. Woo, first try. Greg on Sports, Penelope, Sunshine, and Tammy Lynn. There are many wonderful days. Today is your special, wonderful day. And I realize there are a million places you could be and a million people you could have celebrated with. You chose to be here with us. The privilege, pleasure, the honor, the joy is ours. Hopefully we can turn some of that joy back to you, make your day a little more special, or begin by helping yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's, Tammy Dunlap's House, Andy's Grill, Bob Evans, and Cracker Barrel. Ooh, my chair just broke, just went into the full recline mode as I was sitting on it unexpectedly. There we go. Whew, that could have been bad. Whew. Free pancakes. Help yourself. Wonderful, wonderful. Hilda B? Hilda B? Let's sing another verse for Hilda B. Thank you, Samantha. See the buffer there? Wonderful. Happy birthday to you. Happy birthday to you. Happy birthday, dear Hilda B. Happy birthday to you. There you go. All the free pancakes for you as well, Hilda B. To everyone who celebrated their birthday today, happy birthday. Thank you for letting us celebrate with you. May your day be wonderful. I've been on streams with Danny on Direct like a couple times recently, and I feel inclined to bestow birthday wishes. I don't know. It's something she does. She grants wishes, and it's infectious. All right, drum solo for the big finish. Here we go. Making that snare snap. There you go. Beautiful, beautiful. All right. Let's see. I think that's all. I think we're gonna jump up to Brian Walshe first. To kick things off this morning, and we might jump to another trial in the also as well. But we'll be doing a couple minutes of catch up as we have a lot happening in the world of true crime and a lot of things coming up as well. So let's see. Let me need to find our audio. There we go. There's our audio. Can you hear?
Your Honor, with the court's permission, would you feel comfortable if Mr. Walsh remained uncuffed, at least his hands during the proceedings, so he can take notes?
Check that with the court officers. I defer to them. I don't have any, as you probably know.
Okay.
I don't have any objection to that.
Okay, I'll check with them. Thank you.
I'll check with them when they come back in with them.
Okay, thank you.
I certainly don't intend to have his hands cuffed during the trial, so.
Of course not.
Of course not. Your Honor, I wouldn't ever insinuate that you wanted to keep him cuffed during the trial. This is the last pretrial hearing for Brian Walshe. The next court proceeding involving his case will
I
be
bought one this weekend.
a jury voir dire, or a jury panel. They're veneer. What do they call it? The name just escapes me now.
Thank you, Madam Clerk.
They're going to pick the jury, and it starts this week. They've got jurors lined up to come in every day all the way till Tuesday of next week. And we're talking like 150, 170 some odd jurors each day. They do anticipate being able to select a jury. And if you say, wow, this courtroom looks familiar, it should. We're in the Karen Reed trial grounds. Hello, Mrs. R.A. How are you doing? You going to pop in and say hi? Nope. There's our defendant.
The motions that came in over the weekend.
Brian Walshe is accused in the murder of his wife, whose body was not recovered, but evidence of her death was. No body. It's a no body trial. He previously was convicted for his role in selling some fake, I believe it was Andy Warhol paintings.
For the record, the handcuffs have been removed from the defendant so that he can fully participate in today's hearing. So the purpose of today really is to go through the motions and eliminate, see where I can
I think she said lemonade.
give you some rulings and some expected rulings. I always say expected rulings because I like to think of a trial as a
I'm going to make it more center channel.
living,
Is that okay?
breathing thing that evolves, not something that is pre-planned. So these are my best guesses. Sometimes I'm making actually affirmative rulings because I know enough that I don't think anything will change, but if it does change, I'll let you know. So I'll just start. I'm going to go through those motions that we went through a couple of weeks ago in the same order as they're listed. Instead of, I'll start first with the pretrial motions. And what we have left over there are the following. And before I move to the motions and eliminate, I'll give you an option to check in on others that you think that I might have missed. So the first motion that I think needs tending to is paper number 184, which is the Commonwealth's motion for use of streaming platform to prevent juror exposure to extraneous matter with an affidavit in support. The defendant did not object. The request is to use the standard Zoom format. The court intends to do that. And so that motion is allowed. There will be no other streaming platform used in this trial other than Zoom. Any questions about that?
Your Honor, just briefly, there's the standard Zoom platform in which remote users are able to unmute themselves, and then there's the other version where they can't. I don't know what the name of that is. Are we
called
using
the webinar.
That version?
We're using the version that they can't unmute themselves.
Thank you, Your Honor.
It's just a setting in Zoom. It's not really a version, but webinars, viewers are not allowed to speak unless they're promoted to host or panelist.
Paper number 185 is the Commonwealth's motion for an order to prevent juror exposure. This is called the stay away, no contact order, so to speak. I don't know that we're going to need it. It's hard for me to judge what is going to be the appetite for either demonstrators in this case. I don't see anybody outside yet. And I'm hoping it stays that way, frankly.
Your Honor, I think the parties are all also hoping it stays that way. In the event that there's any information suggesting that there might be any sort of demonstration outside, how could we communicate that best to the court, information that we might...
Through the clerk. The best point of communication always is Madam Clerk.
Thank you, Your Honor.
So if things change outside, and I have a skewed version of it because I sit out on the back, so I don't see what's going on out on the front of the building, but if it changes, you let us know, and I won't hesitate to order that, because of premier importance to me is keeping that jury that we pick in their fair and impartial state throughout the entire term of the trial. So the supplemental questionnaire, I'll get that to you today. I did add in, as requested by the defense, or I changed those 3 questions to be 3 separate questions. I added in the additional question that the defense asked. I think we, at the side of the bench on Friday, the Commonwealth indicated to me that it didn't have any additional edits to that. And I did see some motions came in this morning. I can't say that I spent a lot of time looking at any of them, but I did see that there was a revised witness list, which the Commonwealth eliminated.
There will be cameras.
Witnesses that it no longer intends to call, and added a few witnesses. Which reminded me, so I'm going to, that witness list as abbreviated, we talked about cutting out the custodian of the records and adding in the defense witnesses to the appropriate subheading. And I, not on Friday, but previously, I think I said to you that, said to the defense to take a look at where I put them to make sure that I put them in the right bucket, so to speak. Have you had a chance to do that? And are you content with where I put them?
Buckets?
I know I looked at it, Judge. I remember, but I think that it was fine. And I'll take a look at it before I leave today, but I think it's fine.
Okay. So what I'm probably going to do is take the new witness list from the Commonwealth and then add those people back into the same spots that I put them on the prior version, rather than try to figure out who the Commonwealth took off. But sometime this afternoon, you're going to get the questionnaire and you'll get the attachment that I intend to, and just take a look at it for the final. We can always make changes in the morning. And while I'm on the topic of questionnaire, I think I told you, I think it's the most efficient way to get the information to you, and the least logistically challenging way is the way I've done it really in almost every case that I'm using a questionnaire now, which is those questions are designed in a particular way such that a yes response requires further follow-up. And so when that person comes in, and I'm pretty sure now that we're going to be impaneling in this courtroom. I didn't think that the last time I talked to you, but based on what's happening in the other courtrooms, I can't get a clear courtroom somewhere else. So we are going to impanel in this courtroom. We'll be using the whisper technology for strikes.
Whisper.
And when the person comes in and is seated, I will follow up on any missing information on the statutory questionnaire and any yes answers to the questionnaire. And then I have a few more follow-up questions if the person's still standing and is still a viable potential juror. One of the questions that I think I'm going to ask in that individual voir dire is to tell the prospective jurors that during the course of the trial, they need to agree not to be on any social media, and they need to agree not to watch the news in any medium. That's a big ask, but I think it's a necessary ask.
You're just going to strip them of their First Amendment rights?
The level of publicity, media coverage on the case. Anyone have an objection to that?
No objection. Objection, Judge?
That's a be on or use?
Ask a question, Judge. I looked at my notes from our last discussion. I read my notes to say you weren't going to give us copies of the questionnaire.
That's right. So how do I do that?
Yes.
So you'll have a blank questionnaire, of course. Mm-hmm. And so what I do is I have the person come in, I tell them in the impanelment script, you fill that out, give us your honest answers to the questions, you fold it together, and you keep that document in your possession. Don't show it to anyone until you hand it to me. So they will come up to the side of the bench, they will hand me the questionnaire. Mm-hmm. I will then recite Juror number 40 answered yes to questions blank, 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 and blank. So you'll know what questions they answered yes to. And occasionally people don't answer, and they'll put a question mark, or they'll write something. And if that happens, I read literally what they wrote and where they wrote it. And if you at any point want to look at the questionnaire, that's fine with me too. I just want to prevent both the time and the paper that's involved. Jury selection is so paper intensive anyway, the last thing you need is more questionnaires. But if you want to look at the questionnaire at any point, that's fine. And then at some point, the very last question, as you know, on the questionnaire says, whether this would disclose anything that would be personal to you. I presume that some number of jurors are going to answer yes to that question. At some point, typically at 1 o'clock, I will have the required hearing under URIP to seal those questionnaires. And you have to give, under the rule, you have to have a hearing. So it'll take about 2 minutes, but we will have that hearing at some point during the early stages of the trial.
Thank you, Julie.
Interesting.
The Commonwealth filed a preliminary request for jury instructions. I just want to bring that to the defense's attention with regard to the elements of all of the crimes, so that if there's any objection to that, the murder one is really the SJC's, and I don't know that you're going to be dabbling with that, but with regard to the others, just take a look at those so that we're all on the same page with regard to the elements that are attenuate to the other crimes, all right?
We have, Judge, and at the appropriate time, we do have an objection to some of their requests, but we'll deal with that when the court wants to.
Okay. I think we're a little before that point, but I'll be happy to hear you whenever you want to bring it to my attention.
Just not now. Because we're a little before that point.
We've dealt with on Friday the motion for change of venue. And we also,
it's not happening.
I guess implicitly, if not explicitly, have addressed the defendant's motion for leave to conduct attorney-conducted voir dire to the extent that the defense is asking for panel. I'm not going to exercise my discretion. I'm going to do the traditional individual voir dire. And of course, you play a big role in that.
Individual.
That's all I have for non-motion in limine pretrial motions that I think that I could give you some rulings on. Before I move to the motions in limine, is there any other non-motion in limine pretrial ruling that you're looking for?
Your Honor, the Commonwealth did file a motion for reciprocal discovery.
Okay.
The defense did provide us with a notice of intent to call Dr. Banerjee and an outline of Dr. Banerjee's opinion if she testifies. The Commonwealth is requesting the proposed potential testimony of Dr. Lakin and Joel Scaletti of Safos Corporation, who are identified as potential experts by the defendant, and also Dr. Dan Feria and Steve Verino of MVP Forensics, also identified as potential defense experts. And also Tim Creamer has been identified as an investigator. Commonwealth is requesting any statements that Mr. Creamer has obtained, and also the substance of any testimony he may offer.
We have no opinion, we have no reports, we have no statements. I will, though, provide them with a summary of what I anticipate the other experts would testify to. I'll do that.
All right, when can you get that to them?
Pardon?
When can you get that to them?
Wednesday.
Seems reasonable.
Works for me.
Any other non-motion and limine motions? All right.
And now the slow pan. Yeah, there's some ties to this.
So I'll move to the motions in limine, and I'm going to
if they're protested,
take
it could
them
be
in
involving
order, I
this.
think, with the exception of maybe one of them when we get to it. I may pull that to the end. So paper number 187 is the Commonwealth's motion to eliminate number 1. It's to provide the jury with a means to review electronic exhibits during deliberations. And the defendant did not object to that as of at least 10/31. Same position today, right?
Yes.
It's allowed. The Commonwealth needs to ensure that the laptop that is in the jury deliberation room contains no other information other than the information that's necessary, the software that's necessary for the jury to review the material evidence.
We will do that, Your Honor. There is a special laptop that will be used for that purpose, and it will be provided to the defense to inspect it.
All right, and that was the second part of my order, which is the defense is ordered to review that laptop before it goes in to make sure that we don't have any glitches. Paper number 188 is Commonwealth's motion in limine number 2. It's to notice of any visual aids defense intends to display during opening statements. The defendant objected to that. Is the defendant still objecting to that?
It is. We are.
The motion is allowed. As to opening statements, I want to see any chalks that you're intending to use. It's for your own good. Because if I determine that there's something on that chalk that is inadmissible, you are not going to be able to use it because you're not going to be able to turn it around. Go right ahead and state your objection on the record.
Well, Judge, I would just like to explain something. I object to it for a very simple reason. I've been doing this for 20 years. I've never had an objection in either my openings or my closings when I've used visual aids. Secondly, I only include visual aids that I know are going to be exhibits that are admitted. If I have any question about anything that I would use visually for the jurors, I approach the DAs, I approach the court, make sure that we're all in agreement that's an exhibit. I don't use
Then why are you objecting to it then?
Because it gives, if I give it to the Commonwealth before I make my opening, they have a roadmap, they have a preview of what we're going to say.
Everyone's supposed to be getting a preview of the evidence.
But not
of my opening and not of my thoughts.
All right. I'm not going to engage in a discussion about this. Any chalks that you intend to use that are not agreed to exhibits need to be shown to the court and to opposing counsel.
Okay, Judge, just so I understand.
And it can be the morning of, but it's going to be before you're holding something up in front of 16 jurors that we spend 2 weeks picking a jury for. No, not happening.
And I don't want it to happen, but let me just clarify something. I understand the court's ruling so far.
Agreed upon exhibits.
Chalks, but not what we know to be exhibits.
If you have, and I know you have, agreed to exhibits, then you don't need to address that. Those are agreed to. You know it's agreed to. You can show those.
Fine.
If you have chalks, different thing, that you want to put in front of the jury, I am not letting you stand up before the jury without me seeing it first and the Commonwealth see it first. It can be the morning of, but I do not want you showing a chalk to our impaneled jurors without me seeing it first.
I understand, Judge.
Doesn't agree, but he understands.
All right. Paper number 189 is
feisty.
Commonwealth's number 3. It's for notice of any third-party culprit evidence. The defense has indicated that he understands what the rules are and you're going to abide by them. There's no ruling necessary. Paper number 190 is Commonwealth's number 4, notice of any proposed reputation testimony. It also relates to, I have them in my notes, see paper number 193 below. 193 refers to any bad character, bad reputation of the victim or any of the witnesses, and alleged prior bad acts of the victim or any witnesses. The defense has objected to that, arguing that he intends to bring in evidence of general reputation evidence. Is that right?
Your Honor, at this point, we don't have have any notice of specific reputation evidence that we'd either offer through cross-examination or in any case in chief for us.
Okay.
The concern I do have is the Commonwealth has indicated they expect to introduce evidence, quote unquote, that Anna Walshe was a loving mother who would never have abandoned her children and was a dedicated employee. So I'm sure the government is aware of the restrictions on how this evidence will come in, but that may or may not be relevant, and so I'd ask the court to revisit this before they seek to put this information in.
All right, Commonwealth.
Thank you, Your Honor. Your Honor, the Commonwealth does plan to call witnesses who will testify as to their observations of the victim at her employment. Her employer will testify, as well as her former employer, who was the New Year's Eve guest, will testify as to her.
Is it Metlu or Mutlu, or how do you pronounce his last name?
Mutlu, Your Honor.
Mutlu?
Mutlu.
Okay, I'll try to remember that.
Sorry, I just realized I could clean up the audio a little
Commonwealth
better.
will be introducing evidence to those persons regarding the victim's work ethic and
Observations or interactions with the children?
yes, Your Honor, observations and interactions with the children.
All right. I'm not going to give you any firm rulings on it. You raised your objections at the time. I will tell you generally that I probably will allow observations of her, not to an excessive amount, whatever that in my mind becomes excessive. But general observations as to the victim's interactions with their children is permissible.
I'm thinking of a number.
The law is clear on this. They can't have specific acts, so an observation would be a witness giving their opinion or testimony on a specific act. And so that's not admissible. What they're allowed
You're right, opinion or testimony.
So observations, how are observations of her with her children relevant, which I suspect may or may not be relevant once we start? And it can't just be a limited number of people. So one person from her work saying that she had a good work ethic, the case law says you cannot do that. It has to be the general reputation of a community. And so I guess we will just raise the objections at the time. I just wanted to put the court on notice that
Right.
any of this testimony could just be inflammatory and prejudicial and invoke sympathy of the jury to hear that she was a great mother and a great employee.
All right. I hear your objection, and I encourage you, and I know that you don't need any encouragement to make the real-time objection at the time of the trial. And I'm just trying to give you some basic guideposts of what my present thinking is with regard to that evidentiary issue. Anyone want anything more on that particular motion?
The slow pan up is awesome.
No, thank you.
I love it.
Not at this time, Your Honor.
Commonwealth's number 191, motion to eliminate number 5, is to allow in-court identification the defense asked for, and the Commonwealth has now given, I see this morning, a list of the witnesses who will so identify. Any issue that I need to be aware of with regard to that?
No, Your Honor.
All right. So that motion is allowed without objection, and the Commonwealth has satisfied the defense's request to provide names as of this date. Number 6 of the Commonwealth's motion to eliminate is to preclude reference to or introduction of irrelevant conduct of testifying and non-testifying police officers and agencies.
This is Proctor.
The defendant objects, and
it's the Proctor
I'm happy
problem.
to hear further argument on this if you wish, but the defense's objection to me was, I wrote in my notes, it depends on what the Commonwealth does in its case in chief. And so you've alerted me to the issue.
Oh, there's an issue.
We'll take it as we go along. With regard to a preemptive ruling in that regard, nor do I think that it would be part of your opening statement, because the opening statement is supposed to be a preview of what the evidence in the case will be. And so the defendant may not open on this without raising it with the court. It wouldn't be expected testimony at this point based on your opposition, or seek to introduce that evidence without readdressing it with the court affirmatively at the time that you're going to do it. All right?
So the door has to be opened, basically.
Commonwealth's number 7 is paper number 193. I think we just went over that with the other one, so I'm going to bypass that. Paper number 194 to Commonwealth number 8, to admit photos of digital devices rather than the actual devices, and the defendant did not object, and that's current today. That motion is allowed without objection. Let me pause on 195 because I think we're going to have to go through. Let me just say, first of all, Commonwealth number 9 is to admit the defendant's 4 recorded interviews with the police. I saw this morning, but I haven't really had a chance to look at it. The Commonwealth supplemented its legal briefing with regard to statements of Miss Minor and of the minor child. I want to look at that, and I want the defense to have an opportunity to look at that. I looked the case over quickly this morning, but I frankly didn't have much time to deal with it. But I'm going to circle back to that motion because I think we're going to have to go sort of on the micro level and start going statement by statement, which is going to take some time. So I'm going to put that towards the end of this hearing. Paper number 196 is Commonwealth number 10, to admit NCIC missing person form for Anna Walshe. Defendant didn't object, correct?
Correct, Judge.
It's allowed. Paper number 11 of the Commonwealth's motion in limine, to admit photos and a short video of Anna Walshe as she normally appeared. The defendant objected. So I haven't seen the video. Does the Commonwealth have a way to show me the video?
I believe we could email it to you, Your Honor.
I meant like right now.
Your Honor, I have it on my computer. If you can give me a moment, I can walk up to the bench.
Come on down.
Great. Generally, what is the video of?
It's her with her 3 children on a rug in the living room of the home.
And why is it important?
The rug, an identical rug was found in the dumpster outside of the defendant's mother's home.
There's the tie, but that's not the reason for the admission.
Make it easy is the video is unnecessary. They could do a screenshot of the video which portrays the rug in question. If I could approach it, I can show you.
Yes.
Yeah, sure.
All right, the audio goes silent for the sidebar, but the judge is now watching a video of the victim with her children on a rug. And the prosecution says, we're admitting this, Your Honor, because we think the rug was the same rug. That is not why they're admitting it. Yes, that's the stated reason, but they would get to play a video of the victim playing with her children for the jurors. And what juror is going to look at that and be like, I don't like her? No. They're going to be like, oh, how sweet. What a great mother. What a tragic situation. So sad that her life was snuffed out prematurely. Her kids, think of her children.
And if their sole reason for introducing that is to simply
inflammatory.
show that that rug was in the home, they can do that with a screenshot.
No objection.
All right. That's the ruling you were going to get, so it's good that you, there is no reason that the video needs to be played. So just take a shot of it, show the shot. Now
they're going to have a still shot with mom
with
playing
regard
with the
to
kids.
the other photos, you need to use, it's sort of like autopsy photos, in my view. Use the least number you can use to get, I understand that's one picture she's wearing a necklace and one picture she's showing the watch or something else. But use the least number that you can use.
If I may, Your Honor?
Yes.
So I agree with that, and we tried to cull it down. So there's one with a jacket. There's one with a watch.
The black jacket?
Yes. There's one with a watch, and there's one with a necklace. We can probably take away 1 or 2 from what we submitted, because I believe that there's one where she's with Mr. Mutlu wearing the watch, so maybe we can delete that one. So we're talking probably about 4.
Your Honor, the other issue is those photos can also be cropped, and there can be a stipulation that the cropped photograph showing a person wearing the necklace, the coat, is in fact a photograph of Anna Walshe. So they have sent a parade of photographs. I think that there's other ways to serve that purpose, and some might be stipulations. So this.
Well, I'll let you work out whether you have any stipulations, but even if you want it that way, doesn't mean that the Commonwealth wants it that way. And the Commonwealth gets to
present their case the way they choose.
Hold on 1 second. I got to take a break.
Okay.
Okay, so we're going to zoom because we can, but nobody knows why. We just took a break. Hold, please. We're going to fast forward just a tiny bit and see why the judge just up and left. It was very, very short, but let's see. We're back now. Waiting for her to come back. I guess she had an urgent warrant to sign or something.
All rise.
It's just a couple minutes. Break was just a couple minutes long.
Board of the session be seated.
All right, I think I was saying that you may be able to reach a stipulation. I don't know if you can, if you can't. But I think I was just about ready to say that the Commonwealth gets to, within the bounds of the evidentiary bounds, gets to present their case.
I appreciate the analogy to autopsy photos. And so let me go back and see if I can do something that's more palatable to the defense.
That's frankly how I see it. I mean, I understand the significance of the various items that we've just listed to the Commonwealth's case, or I think I understand generally what the significance is to the Commonwealth's case. So I'm inclined to let them have the photos that they're going to need to make those arguments. But they don't need to be inflammatory. And so, yeah, just look through the lens of an autopsy photo.
Thank you, Your Honor. I appreciate that, and I'll work on it.
All right.
Knowing full well that we don't have autopsy photos.
Commonwealth's
in this
motion
case.
number 12 to admit evidence concerning the defendant's federal charges. And the defense is opposing in part.
That'd be the forgery stuff?
I'll hear from the Commonwealth first on this one.
Your Honor, we have actually attempted to develop a stipulation. The Commonwealth had sent it to the defense, and we haven't heard back as to whether that is something they wanted to stipulate to. We had been working on potentially reaching an agreement as to what information about the federal charges would come in.
All right. Well, to aid you in your discussions, it seems to me, and this actually overlaps with regard to the one of the other motions with regard to the interviews. I understand the importance of the federal case in terms of the Commonwealth's argument with regard to motive, and particularly the timeliness of certain information vis-a-vis the time that the Commonwealth indicates that they believe the defendant did the acts that he's charged with. And the one area that I wanted to probe so that I have the information firmly in my mind, what the evidentiary significance of it is, the weight of it versus the prejudice, is the GPS. So my memory from prior proceedings on this case is that the GPS was not the way that the Commonwealth found out that Brian Walshe was at various places.
That is correct, Your Honor.
All right.
It was not a GPS bracelet.
What was it?
It was a radio frequency bracelet that would go off if he went a certain distance from the home, and he would have allotted amount of time to leave the home to perform errands and drive the children.
Okay. So there's no evidentiary, there's nobody coming in and saying based on his bracelet, he was at X, Y, and Z. They found that from the phone, right?
That is correct, Your Honor. They found it through the two phones.
So that seems to me to be both in the transcripts and also just to the extent that it's in any of the federal papers as a condition of release, highly prejudicial. And I'm not inclined to let the jury hear about that. It's not relevant to their decision making, and they may, even if I give them a limiting instruction, may make it difficult for them to
So they can't know
accept
about these
limiting
other
instruction.
because it would
Doesn't
be
have
like,
any
why are you
evidentiary
wearing the
value.
bracelet, right?
So anything with
It's like a
regard to both in
proximity
the
bracelet.
interviews,
Ankle monitor.
which I know we're tabling for later on, and or in the federal records, that seems to me to have very little evidentiary value to the Commonwealth and has a potential for prejudice to the defense. So that won't be in.
Understanding you've made a ruling, can I make an attempt to change your mind?
Sure.
All right, thank you, Your Honor. I appreciate you giving me this opportunity.
The trips to dispose of the body.
With the defendant's ability to have windows of time that allowed him freedom to leave from the house, it allows the Commonwealth to show the premeditated nature of this crime and that he had windows to clean up after the crime was occurred.
That's a different thing, though. The fact that he has windows of time that he, or certain parameters that he has to be at home, and that comes up in the interview at one point when Attorney Minor makes mention of that. And I don't know what we're doing with that yet, but
okay.
Putting that to the side, I don't think that what you just said about windows is the same thing as I'm saying about being on an electronic bracelet.
Okay. Okay.
I think there's different prejudice that attaches to those two things. The fact that he had restrictions, that he was on federal supervised release, and that he had some restrictions is going to be known to the jury. It's integral to the case. But the fact that he's on an electronic monitoring bracelet is a different thing, in my mind.
Thank you, Your Honor. I understand your rule.
But keep on objecting, as I know you will. But that's sort of the dividing line that I'm drawing in my mind's eye right now. And keep on working on the stipulation.
Yes, Your Honor.
Paper number 199 is Commonwealth's motion in limine number 13. It's to admit the victim's out-of-court statements, evidence of her state of mind, and the defendant's motive to kill her. The defendant is opposing it in part.
On confrontation? What?
I'll hear from the Commonwealth first.
Thank you, Your Honor. The Commonwealth would seek to introduce the victim's out-of-court statements to Alyssa Kirby and to Mr. Mutlu and to Mr. Fastow as to her state of mind, which was known to the defendant. Your Honor, certainly the defendant, the evidence will show that the victim had a meeting with a friend, Ms. Kirby, on the 29th of December and told her about the big argument they had had over Christmas.
Give me a timeline because I want to have this in my head. She comes home on Christmas Day.
Yes.
Anna comes home on Christmas Day. She drives because she missed the flight. She spends much of the day driving, and then she gets there on the evening of the 25th.
Yes, Your Honor. I believe it'd be around 8 o'clock.
When did she drive back?
She leaves on the 26th of December.
Okay. And she drove back to D.C.
And she drove back to D.C.
And then she returns back to Boston by flight on the 30th.
On the 30th.
Okay.
All right, that's helpful. All right, go ahead.
Your Honor, on the 29th, when she's still in D.C., the night before her return to Boston, she goes out to dinner with her friend Alyssa Kirby and talks about the big fight that she and the defendant had, and tells Alyssa Kirby
she'd been home for Christmas.
Yes, over the Christmas break, or the day that she was home. She tells her about that big fight, that she gave the defendant an ultimatum, that she had learned that the reason the children weren't with her was because of the defendant and his attorney, and that she had told him essentially to just resolve the case, even if it meant taking jail as a result. And I know Your Honor has reviewed the paperwork, and it is a little more detailed, some of the statements at grand jury. Your Honor, I would suggest that this is admissible because certainly it shows the victim's state of mind, that she is prepared to do what she needs to do to take her children down to D.C. to be with her. She had a very highly compensated job, and I know Your Honor is familiar with the circumstances of her moving to D.C. without the defendant and the children. I suggest that that is certainly known to the defendant. He acknowledged and alluded to a big fight over Christmas in the recorded interviews, and indeed said that he had learned after fighting with the victim previously over Christmas, and I believe he said Thanksgiving, that he was not going to fight with her over her alleged need to return to Washington, D.C. for a work emergency. I suggest this is highly probative of the victim's state of mind and the defendant's motive to kill her. It also shows that he is aware of this. He's searching Mr. Fastow's name. He's searching for divorce, and he is conducting those searches in between. I believe the search for Mr. Fastow was on December 25th, and then he's searching for divorce, I believe, on the 27th. His mother then hires the private investigator to investigate Anna's, whether she's behaving appropriately for a married woman. That's on the 28th. Certainly suggested all of this is highly relevant to the victim's state of mind and the defendant's motive to kill her and what happened in that home on the 1st of January. And with Mr. Mutlu, there is some testimony about Anna Walshe had some conversations with him, I believe, on the 28th. And Mr. Mutlu's testimony is a bit indicating in some of his statements that some of it he might have learned from other people, but some of it he did learn from Anna. And certainly the Commonwealth would be very careful to make sure that we were only eliciting what he learned from Anna, not something he had heard from somebody else. And I would suggest that that should all be admitted in this case.
All right. Defense?
It's going to be a spicy trial.
The problem I have is the Commonwealth is also cherry-picking parts of these conversations. The dinner that they're speaking about, her and her friend were out until 1:30 in the morning, a night that ended at a karaoke bar. So there was probably copious amounts of alcohol, I would assume.
But that goes to the weight the jury chooses to give to it.
But in the context, I think it's important. The other thing that the Commonwealth didn't seek to introduce is the fact that Alyssa Kirby at the grand jury, at her grand jury testimony, said that they had a very open and honest relationship, and that Anna wanted him to do whatever he had to do so the family could be together. And further, she didn't say that she wanted a divorce or was going to leave him with this ultimatum. Specifically, Anna supposedly said to Alyssa Kirby that she wanted him to choose life because he had been so depressed. And even if he had to go to jail, that will be waiting for you when you get out. Mm-hmm. So I think they're not only cherry-picking what portions of this conversation they want to put in, they're overstating the relevance, especially in light of the case law. When you look at the cases that talk about state of mind, they cite Castano. That was a situation in which the witness had told the defendant in that case that she wanted to end the relationship, that she had rejected his anniversary presents, not only was ending the relationship, but has packed up his bags. And when the police responded to the scene, there was, in fact, a packed suitcase of the defendant's items at the door. That is not what we have here, let alone to that level. In Martin, the statements that the government was seeking to introduce were basically statements in history of physical abuse, violence, of her trying to take the children from him. That is not what we have here. Half of the conversation to Miss Kirby was how she wanted her family together. They had an open relationship. Couples fight, so to say they had a big fight on a date, she was late for Christmas and they had 3 children. This was not earth-shattering motive to kill information. So I don't think it's fair that these conversations with Alyssa Kirby come in. And certainly if the court does see value in those statements as the case develops, then the doctrine of verbal completeness would force the court to allow all those statements to come in, because this was one conversation. So that would be our position with respect to Alyssa Kirby. With respect to Jem, I think there needs to be either a voir dire or some clearing up of what he heard from other witnesses and what he specifically heard from Anna. And again, Mr. Mutlow was with them on New Year's Eve into the 1st of January until about 1:30 in the morning. And he's also described the night as joyous, that they had a happy marriage. The federal case had been going on since 2018. They had been weathering this storm. And so, again, if they're seeking to introduce statements, I think that the full conversation would come in to show the context, and we need to figure out what exactly Mr. Mutlow heard directly from Anna.
All right.
Is it Mutlow or Mootlu?
So let me give you some guideposts.
Or are there two people?
The defense in its opposition cites to Qualls, which is sort of one of the earlier and seminal cases on state of mind evidence. And, but I'm not persuaded by the defense's argument with regard to what Qualls stands for in light of Castano and in light of which, for the record, Castano's at 478 Mass 75, a 2017 case, and also look at Commonwealth versus Bins, B-I-N-S. That can be found at 465 Mass 348, a 2013 case, at head notes 17 through 22. Under that case law and other cases that I looked at, it is very likely that I'm going to allow Anna Walsh's statements to Alyssa Kirby, limited purpose of establishing her state of mind as is relevant to the defendant's motive to kill his wife.
And what
to
about
the
rule of
extent that
completeness?
such state of mind evidence includes statements describing his defendant's prior bad acts. His federal case on his statements will be admitted, and with a limiting instruction that it is limited to show the defendant's motive and not to show that he had a bad character or propensity to commit any other criminal offenses. There's a limiting instruction that is posited by the court, the SJC and Bins. It's on the bottom of
this is a
top
murder
of page
trial.
419.
He's alleged to have
Take a
murdered
look
his
at
wife.
it. That's what I'm likely going to give you.
And disposed of her body in pieces. All well under federal monitoring.
I think that the parties need to do a little bit more work with Jem, and they will, as the Commonwealth gets ready to prep him for his trial testimony, and obviously be in touch with the defense with regard to what that pretrial work reveals with regard to statements that were made directly to him from Anna, as opposed to third-party other evidence that would not be admissible.
Yes, Your Honor.
With respect to William Fasto, there's one notable exclusion or sustained you're going to hear. The statement that she makes to Mr. Fasto about she doesn't know what the defendant would do if he were to find out about the affair is not her state of mind evidence and is not admissible and is prejudicial. So don't go there.
Yes, Your Honor.
Don't go there.
And then, of course, with regard to the doctrine of completeness, I think the defense has an argument there. And
I agree.
So I'm inclined to let them bring in the other statements. And you can oppose it if you want, but that's
coming
sort
in.
of the guidepost that I'm setting right now.
I love this trail. The setup's great already. Now the prosecution has to see if it's worth bringing it in.
All right.
Because of the rule of completeness.
Paper number 200 is Commonwealth 14, to allow the admission of text messages conversation as of 11/12. I wrote the defendant had not filed a written objection. I think I invited that at our last hearing, and I'm guessing that you didn't because it's 801D2 stuff, but you let me know if it's otherwise.
So, Your Honor, with respect to the text messages, I think maybe we have some objections to some of the portions of the text messages, but specifically, and I did talk about this in
Another paper?
Defendant's response to Commonwealth motion in Lim 13. The William Fasto text messages, I don't think that any of them are admissible and the jury should not receive them. There is no evidence about state of mind in them. It's text messages about two friends who are having an illicit sexual romantic affair. There's no evidence by the government other than speculation that Mr. Walsh ever even saw these messages.
Is it speculation? I mean, he says in his own words in the interview that somehow her text messages are showing up on my phone or something to that. And I'll go back and listen specifically, but we did cross this issue once before, and that was my recollection. Maybe it's a failed recollection.
No, the statement that you're referring to, there is a conversation between Mr. Walsh and the police where in the same paragraph he says, iMessenger, not iMessage. And then there's talk of Facebook messages popping up on its phone. So I don't think it's clear. And even if the court were to infer that iMessages came to his phone, there's no indication that those came to his phone. The text messages with Anna Walshe and Will Fasto ended at about 10:30 on New Year's Eve. Mr. Mutlow was at the home until 1:30. He specifically said, either during an interview or his grand jury, that at no point did he see Mr. Walshe on his phone. He didn't see Mr. Walshe on his wife's phone. He, again, described jovial, happy, up until the time he left at 1:30. So I think it's a very thin speculation that he saw these messages. If a foundation is laid during trial that indicates that he did see them or he did know them, it would be different. But otherwise, these text messages are hearsay and they're not admissible for any purpose.
Any purpose.
How are they hearsay? In order, and what I'm focusing on is what in them, is to prove the truth of the matter asserted.
Well, then
I guess we'll have to look at each, and that's sort of where we're going to end up with the transcript, I suspect.
Well, then it kind of reverses the question back to the government. Why are they seeking to put this text message history in? They're putting it in because they want to wave it around and say she was having an affair and he knew and he killed her. That's what they want to do. And I think if there was actual evidence or proof, other than speculation, that he had seen these messages, was angry about them, we'd be in a different posture. But that is not the case. And so why are they trying to put them in? And hearsay, her messages, her statements are hearsay. So what other purpose is it coming in for? I don't see a purpose other than to just wave this in front of the jury. Mr. Fastow is going to testify. He can certainly testify to the relationship between him and Anna, the duration, the time, but those text messages should not go in front of the jury.
All right. Kamal.
Please.
Your Honor, in addition to the defendant making statements about her iMessenger appearing on his phone, he also told the police that her phone was upstairs on New Year's Eve. He told police about some quarrel she had had with someone over text message and that had been put her phone upstairs in their bedroom.
Abdullah.
Yes. That's different than Mr. Mutlow's testimony that she was using her phone all night. So I suggest
she says
that's certainly.
Let me ask you this. Based on the forensic work done on the defendant's phone, is there any evidence that he was on his phone that night?
No, Your Honor, there's not.
Okay.
That's the phone that was
missing.
Misplaced.
Right. But you do have evidence, this has been the subject of other motions, that on the first and into the second, that there was some manipulation of that phone to unlock it. So I guess what I asked you, and it was a sort of a void in my mind of whether there was any evidence that he was on his phone on the 31st, and the answer to that is no.
The first time his phone was manipulated was at, I believe, 7:35
in the morning of the 1st. All right, just trying to get the facts in my head. Well, more to follow on this as to individual text messages, and I want you to be focused on whether or not they are being offered for the truth of the matter asserted, and if they are, what your positions are, and see if you can make some headway on this.
Thank you, Your Honor.
Oh, Your Honor, the only other thing with respect to the messages, and this could be an email instead of, I just wanted to, we can certainly check, but if I could have the government verify if the messages they are proposing to introduce between Mr. Walshe and the other witnesses, if they have been edited at all, because we have like pages of text messages over a couple days to various witnesses, and I don't know if that is just the chunk that they are taking or if they went in and cut out any messages.
Okay. And by the way,
I'll talk to the counsel afterwards.
Okay.
By the way, this motion that I'm talking about, we started to talk about Mr. Fastow and Anna Walsh's text messages. But to the extent that they're the defendant's text messages, which were the subject of this, then that's in a different bucket in terms of evidentiary ruling. Maybe not as important to you either, which is why you went to the other.
We might need a bucket counter. We've had 2 so far.
Commonwealth's number 15 is to admit internet history from devices in the defendant's residence.
Yes, please. Yes, please. Thank you, Judge.
Has produced 2 binders that they expect to introduce into evidence. One is a binder of the gray MacBook, and then the other one is a binder of, I only have 2.
I think it's silver MacBook. They don't make gray.
Okay.
Like space gray.
All right.
We appreciate that.
Are these for my own, sorry to interrupt you, but are these similar, if not the same, from what came into grand jury?
They're not the same to what came into grand jury.
Okay, because I'm familiar with those from the prior briefings.
This is significantly more material than what came into the grand jury.
Okay. Is it the same sort of format, though? There's a search and then the result of the search?
No, Your Honor. This would, I would suggest, be from a Celebrate report, and we have copies here that we can give to the court to review.
Okay.
But the Celebrate report for the MacBook pulls from 2 different databases, so you see the same search twice or the same visitation twice.
So let me ask you this. I have some questions that I need to process in my head.
Yes.
The searches that are done, is there forensic evidence that shows that the searches were done on the MacBook Pro?
Yes.
And not on the iPad?
Yes.
All right. That's what I suspected, but I haven't asked and nobody told me that. I assume that that was the case.
Yes.
Because that was not the state of the evidence, as you know, at the time the case was indicted.
Yes, Your Honor.
So, and from that time, and that is March of 2023 when the case was indicted, are you saying that the forensic work has uncovered additional searches beyond what was known at that time?
Yes, Your Honor.
Okay, and what's the volume of that?
So the MacBook report, that report that was generated is approximately 1,000 pages long.
Okay. Is that where this search, I hate to be so graphic, but well, it's not that, this isn't that graphic, but
not the same courtroom necessarily.
In paper number 201, I learned of a search that I had never seen before, which is the...
We're objecting to that one.
Right.
Okay.
So that was not part of the grand jury?
It was not part of the grand jury.
What is the date of that search?
That is, I believe, forgive me because there's so many, but I believe it's in and around Christmas.
So it's
before
January 1st?
Yes.
Is it around the same time as the divorcing?
Yes, Your Honor.
Around the 27th?
If I may, I have a cheat sheet for myself.
12/27.
It's 12/27, Your Honor. And it is approximately 8 hours before the searches for divorce.
So, Your Honor, there were more searches and hits in general on this topic, as you might see on someone's device. This particular search, the name was, I'm trying to be,
discreet.
It was also about having a threesome and impregnating someone. There's multiple searches for porn. He is an adult male.
What?
So I think to just cherry pick this one, and
I don't care about the porn part, so to speak. I mean, that is the, it's inflammatory, but it's the second part of that search, cheating wife. So that goes to the issue that we just talked about before, about his state of knowledge and what reasonable inferences can be drawn from that search being done on the 27th. That goes to that is an argument with regard to his state of knowledge on the 27th as to whether or not his wife was having an affair, right? I could care less about the porn part of it.
No, I understand. I think that without getting into a semantical discussion about pornography, I think that there's millions of different interests, predilections of what people might watch or like, and I think that it wasn't just cheating wife. It was cheating wife has threesome and gets impregnated. So to say that could have been ancillary to what the content of the material was.
What
so
an
I think
argument.
it's inflammatory. So when the
Right.
court
So there's this body of evidence of searches now that are not in my mind because they were, and it's not that it's inappropriate, that's why we have these hearings. But what would be helpful to me is if the Commonwealth, A, can provide me with those searches, and B, if you know, and it's not too much additional work, identify, and maybe it will become apparent to me because there's only the list
That's
of what
the
you
impregnant
knew
part.
at the time of grand
Becoming
jury
apparent.
is pretty much encapsulated both in the grand jury transcripts but also in the affidavits.
Your Honor, we're prepared to give you the binders and a list of the items that we would seek to elicit at trial from the binders.
All right.
And we'd give that, of course, we've given the binders to counsel, but whatever we give to the court, we give to counsel.
And then if there are particularized searches that the defense is objecting to, I know you will raise them with me.
Wow.
And as a matter of logistics for how the jury is going to be presented this is even the stuff from grand jury, which I printed out because I'm still old school, is binders worth of materials that I have still with me. How are you going to present this to the jury?
So, Your Honor, we have, that would be tagged as an exhibit, a binder, but then it can be
viewed,
broadcast on these different monitors. So we can ask the witness about a certain entry in the report and put the entry on the screen and then have the witness testify from the screen saying this is what occurred in this entry according to the report.
All right.
This is going to be some trial. Ooh,
Just an awful lot of material for them to absorb.
We understand that. It's also important material to the Commonwealth's case. And so it's not an easy examination, but we do believe that it's important, and we've tried to make it as streamlined as we can.
All right.
Your Honor, too, just so the court is clear, I believe the government's position is that they're going to put in 3 or 4 actual binders into evidence, so the jury is going to get a giant binder of 1,000 pages. And so at what point does that become cumulative and prejudicial when they just drop by? And I'm just trying, is there a way to streamline this, or is there a way to cull some of it? Maybe that's something we can all work on. I just wanted the court to be aware that that is the intention.
More to follow.
More to follow.
There will be more. Wow.
All right. Paper number 16, to introduce Axios investigations hired by Diana Walshe, December 28th, 2022. Defendant is opposing. So what is it? Is the Commonwealth just seeking to admit through a person, presumably, that comes from Axios, because Diana Walshe is not on the witness list?
Yes, Your Honor.
So
we listed her as a witness, Your Honor. We don't know if we're going to call her, but we did list her in an abundance of caution.
all right, I'll make sure that she's.
I apologize, Your Honor.
I don't think she's on there.
It could be a clerical error. But
Okay, so keep that so that.
She's also present in the court right now, Your Honor.
Oh, hey. Hi. How are you doing?
Well, do you want to do anything about that?
I didn't know she was on the witness list, so I didn't move to, I didn't
Sequestration?
move to sequester her for this hearing. So I didn't understand that she was going to testify, Your Honor. I apologize.
All right. So
Still no motion made.
I can tell you what I would intend to introduce at trial from Axios. It's just very simple, a contract that was executed.
right, which I've seen.
Yes.
It's a grand jury exhibit.
Yes, Your Honor.
What's the objection to that?
So, Your Honor, what's the relevance of someone who the government isn't calling as a witness to introduce something that they did on the 27th of December?
Well, the relevance, and frankly, I'm going to ask that Ms. Walsh leave the courtroom.
Thank you, Your Honor.
You out.
I can speak more freely in a moment.
Mm-hmm. Thank you.
See ya. Awkward.
So, Your Honor, the evidence that the government has provided us suggests that Diana Walshe contacted Axios Investigations on December 27th through email and phone calls, that she signed the contract, that she paid for it. In the grand jury testimony, Jeremy Dozier states that Diana Walshe specifically said, I don't want my son to know about this. So they're trying to basically say, she did this, we have no evidence that he was part of it, knew about it, directed it, paid for it, and it's just prejudicial and inflammatory.
I read somewhere, and it has to be in the grand jury, I read somewhere that the connection to the defendant is that she wanted to do this for some time because of the psychic, and that she went to the defendant or said to the defendant, I want to do this, and that he tried to rebuff her and say, no, I think his words were, Anna's a good girl, and, she's not having an affair, something to that effect. But then I also read somewhere, it has to be, again, in the grand jury, that he then gave her the name of Axios. So even though he said don't do it, he gave her the name of the company that she hired, right?
It's like a tacit support.
If the government is going to elicit that information.
The only way that comes in is through Diana Walshe.
And they did not list her as a witness. So even if there was evidence that the government was planning to introduce that Mr. Walshe supplied the name, that doesn't indicate he paid for it, knew that she finally did it, was interested in the results. The evidence we do have is that the mother saw a psychic, and even the the evidence suggests that when Mr. Walshe was speaking to other people about it, he was dismissive of it and even told his wife about it. So I don't think it's appropriate that they get to introduce the contract or the fact that Diana Walshe hired a private investigator on the 27th unless they're going to call a witness to link it to him and that he knew about it, wanted it, and was invested in the results. Otherwise, it's not relevant.
So, Your Honor, you were right about your memory of the grand jury testimony. That statement of the defendant giving the name Axios, that comes from his mother. So,
but you don't have her on the witness list, so how do you make that connection without her?
That's fair. We were suggesting as a reasonable inference by the amount of contact the two of them had, and that he saw her frequently, and that he talked to her frequently over the phone. But again, we were trying to be very limited with what we were entering. It was just the contract through the private investigator. So with that, I think Ms. Porges, her assessment of the evidence is correct. And so I don't want to belabor this issue. That was the only thing we were trying to get. We were not trying to get any statements of the defendant, nor were we trying to get any statements of his mother, simply the contract.
Well, you make whatever strategic decisions you're going to make, but that may lead for a paucity of evidence on linking his knowledge to it. That's your choice.
Understood, Your Honor.
All right.
This is going to be one spicy trial.
Number 17 is paper number 203, and no objections to the calendar.
There isn't, Your Honor, but given the fact that my understanding is that there's going to be a blank calendar and items or notations may be placed on it, and I'm assuming then that is going to go to the jury. If that's the case, then the defendant would also like access to also add or denote things on that calendar, and we can color code it.
We can all write on the calendar together.
That's what I would ask for. Or we can have two calendars, which seems superfluous if there's one.
We were just looking to give each juror an empty calendar so they could make their own notes and it would be part of their notebook, not something like that witnesses would be using.
So you can instruct the jurors?
If you want to give a blank calendar to the jurors so they can keep track of days, then that's fine.
Write this on your calendar?
Confusing during the grand jury.
All right.
Google, people. Google has a great calendar.
206 is allowed, sequestration of witnesses.
Okay, there we go. Now witnesses
207 is a review. Commonwealth took no position.
Your Honor, may we be heard sidebar?
Yes.
Oh, man. I'm loving this one already. Let me tell you why. Already, as we zoom, we can skip ahead. So we're catching up. already just the way that the prosecution is referring to somebody as Mr. Mutlu, and the defense is referring to, I believe, the same person as Mr. Mutlow, they do not see eye to eye. We do not have a happy little agreement anywhere here. And as a result, we're going to have some spice in this one.
Parties
hang on,
is the Commonwealth's...
Hang on. Back up. Okay, here we go. I was going to ask that too.
So paper number 208, which is now we're moving to, did move at paper number 206 to the defense's motions eliminate. Paper number 208 is defense number 3. That is now mooted and requires no ruling.
But Miss, that's the lady they just kicked out briefly.
Paper number 209, defense 4. Right? Commonwealth has indicated they will not seek such opinion, so no ruling is needed. Paper number 210, defense number 5. Commonwealth will not seek, no ruling is necessary.
Your Honor? Might we ask that a similar order regarding any awards or commendations for any defense experts that may be called? That they may not elicit that from those
a little
experts.
tit for tat there?
Well, to the extent that it goes to their qualifications, they need to do that. They need to know that the person's qualified, but no excessive lauding. How about we say that? On either side.
Just Linda, good morning. Thank you. 5 months of support. Appreciate that.
Paper number 6, defense's motion in limine regarding any opinion that the defendant knew about the extramarital affair, and that was opposed by the Commonwealth at paper number 230. And as I understand the respective positions of the parties, is the Commonwealth's position is it's not seeking an opinion as to that, but is going to plant breadcrumbs such that a jury could, or could not, but they're hoping they could, infer the same.
We're going to zoom in on our note.
They're not eliciting an opinion, so that answers that.
So that seems to be the line that the rules of evidence draw as well.
That's, I believe, the defendant's mother.
Paper number 7, defense number 7.
Teresa, OG, 30 months. Thank you very much, Teresa.
What did I write here? Oh.
Thank you, Cameron's NBC.
It's paper number 212, and it's regarding opinion evidence, and the opposition was at 231. And I wrote to myself, what more do you want? And under what authority?
Well, all I'm trying to do, Judge, and all we're trying to do is keep these witnesses from taking the stand and start offering opinions as opposed to the facts of their investigation, that they not be asked opinions that they have not provided in all of these reports. Because when you read through the hundreds of pages, and what they've given us is all this search data and everything, that's fine. But they can't then elicit, do you have an opinion about what this means? They can't do that, and that's why we filed this motion. That's all.
I'll hear from the Commonwealth.
Thank you, Your Honor. Your Honor, we've provided voluminous discovery in this case.
Voluminous.
Certainly, we expect that the witnesses will testify as to what they did in conformance with their reports. They'll explain their reports to some extent, but the defendant has all this material that has all been provided. So we would, if there's something specific they're looking for, but again, the witnesses will not stray beyond the reports that have been provided.
All right, then we have no disagreement. As an aside, by the way, it is somewhat surprising to me as I was looking at this issue how little is said about experts in the context of, or how little is required by the rules in stark comparison to the civil rules. And I can't resolve that in my mind why the drafters of these rules sort of make a heavier burden on the parties in a civil case with regard to expert testimony than is expected in a criminal case. I don't know why. Curious.
If I may?
Yes.
I suspect it's because in criminal cases you have procedural due process bumping up against substantive due process, and that's not present.
Would you think that would then err to the side of more disclosure for the defendant?
I think less, because fair trial strategy, and that might be different. That would be my thought.
My thought when I was sitting in the back is, why don't they have to produce what they have to produce in a civil case? But I don't write those rules. I just try to interpret them.
I don't want to belabor this point at all, but I remember Stephanie Page filing motions for depositions because you allowed depositions in civil cases.
Right.
And we were always shut down saying no, and we asked the same question the court's asking.
Well, I'm asking that question, and I almost never allow depositions in a civil case, even of the experts, but regardless. It's just a curiosity.
I can't begin to tell you how excited I am for this trial. We've got characters on both sides. We've got attitude on both sides. We've got a judge that seems to be sharing quite a bit of her thought process with us.
Paper number 213.
And has an attitude
opposed
herself
at 232.
Bit, but not a bad one.
And then another rebuttal
Seems
at 281. Fair. To exclude defendant's request to consult with an attorney or statements of prior counsel.
She is right in the middle of it, but I think it helps her make a good decision.
And I got more on that today, I think, too. Let's pause on that one. Bad acts, 214, paper number 9 for the defense. I think we've discussed this. It's opposed by the Commonwealth in a partial opposition of paper 233. And I had written to myself in my notes, question to the defendant specifically, what additional statements from the recorded interview does he want to exclude? But we're going to get to that in a minute. Paper number 215, defense number 10, motion in limine regarding witness characterization of evidence or of the defendant's behavior. The Commonwealth has said it will not seek character evidence, but will offer evidence of the defendant's behavior through observations. Is that right?
Yes, Your Honor.
All right, that seems reasonable and likely where the line's going to be drawn. Number 11, paper number 216, asking the Commonwealth to designate and provide notice of specific statements and internet searches contained in the digital data seized to be introduced at trial. Anyone wish to be heard more on that issue?
Your Honor, the Commonwealth did file a responsive pleading, paper 234.
I saw that. I will say that the Commonwealth's opposition at 234 seemed to take a reasonable approach, and likely where the line will be drawn. Is the pillowcase and the pillow, that's all over, right? There's nothing there.
We're not going to intrude you, Your Honor.
And there's nothing other happened with regard to this is just a hanging, dangling from the prior motions, the dinosaur, teddy bear, that's nothing I need to worry about.
Nothing you need to work on. We sent counsel a list of photos we were intending to introduce. I think that we cropped out any images like that, and so if there's any issues, they'll let us know.
All right. So how do we take on this, what the remaining issue that I really want to address today, and then I'm happy to talk to you about anything that you need to discuss with the court, is these transcripts. And I had about 5 minutes to look at the case that the Commonwealth has now cited in its most recent briefing of this morning, and I want to give it a closer look. But one way that we can approach this is to literally go line by line. I know that the defense has indicated, and I appreciate the way that this was laid out in the briefing, because it makes it very clear as to what it is that you're seeking and helpful. So I appreciate the work that you did to get that in that shape. And you've stated your objections. So one way I could do this is to just go through on this list that you gave to me and rule at some time between now and before the evidence is played, and give you a little bit more time to brief it. I will say that as I said to you at the side of the bench on Friday, that I think that there's a evidentiary issue that needs to be decided with regard to what the scope of the employment of Ms. Minor was. And I'm not sure how this new law fits within that analysis. If it does, if it's just a separate analysis, it almost seems like it's a separate thing completely.
Sorry, I was distracted.
And a separate vehicle or avenue to admissibility, these adopted admissions. But I want to give the defense time to respond to that because it just came in this morning. And
we're in Boston,
Massachusetts. As to many of these statements, and so that you don't misunderstand where I thought I was on Friday, which was alerting you to the issue of agency, I'll call it. And I don't want either of the parties to be misguided by what I said to you on the side of the bench with regard to that. And what I mean by that is this. Even if Ms. Minor's, Attorney Minor's statements aren't coming in, even if they weren't coming in, I never intended to not allow the Commonwealth to tell the jury that she was present there. So whether her statements come in is very different than whether her attendance at the interview was going to come in. And I think in the opposition that I saw, the papers that I saw flying, I think the Commonwealth, maybe based on what I said at the side of the bench on Friday, thought that I was excluding the latter as well. That is, her attendance at the interview. I also want to remind you of something that I said at the side of the bench on Friday, which is much of what Attorney Minor says is repeated by the defendant. And so the cumulative impact of those statements is not significant for the most part. There may be statements that she makes that are significant.
I want to take off my glasses and play with them now.
And I'm sure the defendant is going to ask for the humane practices instruction. And if that is the case, it would seem to me that the dynamic of what is going on in that home during those interviews is relevant to that, specifically Thomas's role. I see you nodding your head no, but then I get to the later interviews. Maybe there's not enough in there for you to care about it. So why are you nodding your head no over there, Attorney Tipton?
I appreciate the time to respond. I was reading their cases at 4 a.m. That's not the best time to be reading cases.
It's not. Sometimes you have to.
I was blissfully ignorant of it at 4 a.m. I didn't see it until 7 a.m.
So if the court's, we will file a written response. My understanding is this court's going to give us time for that. And when's a good time to have that filed? You said you would make a ruling before the evidence started, so
right.
I'm just wondering.
I mean, honestly, the next couple of days we're going to be busy with picking a jury, and maybe even longer than that. So, I mean, I don't. As long as I rule on it, yeah. As long as I rule on it in time for you to make the appropriate edits, and I don't ruin, the poor IT person that's going to be tasked with doing the edits. Thanksgiving. How deep into the case are these transcripts coming in?
Potentially the first day, Your Honor.
Great, thanks.
But the good news is, like you said, a lot of it was cumulative. And so in going over that, particularly the interview in the 7th, when we looked at it, we're like, there's really not a big problem with a lot of these. So we'll start working on some of those redactions. And we gave a list to the court of the things that we didn't object to. So we're going to start working on this.
So curiously, and I just want to make sure that this was a conscious decision on the defense's part and not something that was unconscious. There's some of what she said that you kept in. You know that. What attorney?
No,
There are some statements that you did not ask to be, and so.
From Tracy Minor, Judge?
Yes.
Well, then that was an error. That's the highlight didn't carry through. Then.
Okay. All right.
Because, and I don't want to interrupt the Commonwealth. And we're going to file a written response. Let me just lay the groundwork for it, though.
Sure.
The court brought up the humane practice. We footnoted in a pleading. We never asserted humane practice. We're not asking for humane practice. Okay?
All right.
That is the bottom line here. And the Commonwealth's citation to sheriff in their latest briefing, they misstate what the law is. The law is if humane practice is a live issue, the court is required by law to give it humane practice. It's not a live issue. We've never raised it. So I want to set that groundwork.
All right. I appreciate that.
Two,
It was getting spicy.
I understand what the court just said about you never intended to indicate you were going to exclude the presence of Tracy Minor. Our prejudice, contrary to what the Commonwealth argued in their brief, in their memo they filed last night, we made it very clear what the prejudice is. The prejudice is from the fact that Tracy Minor is there and all these statements are being made. Not the statements necessarily of Tracy Minor, but the statements of the client. And we made clear what we think the prejudice is. And that prejudice, once again, we'll lay it out in more detail, but that prejudice is the same type of prejudice that flows from the Commonwealth's reaction to Proctor and I won't go into anything about Proctor except for the fact that once Proctor's integrity was impeached, the Commonwealth moved away from him. Why? Because his impeached integrity reflected on this office, the Norfolk County District Attorney's Office. Our prejudice is that what happened at these interviews, that Tracy Minor was there, that the jury can take that to say, as we said, either he's lying to his attorney, therefore he's lying to us, and they can't believe our representations during the trial, or his attorney was complicit in the misrepresentations he was making to the police because she chimed in, but she was there, and so now we're making misrepresentation on his behalf. That's the type of prejudice we're trying to avoid. And finally, we're going to be arguing, why is it relevant, especially when you take the humane practice out of it? There is no relevance to Tracy Minor being there. So we'll brief it, but I wanted to lay the groundwork for that.
All right. So I appreciate that preview.
Passionate preview.
And I appreciate the reminder with regard to the humane practices, both for myself and also to the Commonwealth as we move forward and try to resolve this issue for you.
And could I just make one more suggestion?
Please do.
If the Commonwealth could take the highlighted sections that we provided to the Commonwealth and you.
Yes.
And just now, go take those highlighted and maybe color code all of these statements they've listed. Wouldn't it make it easier for us all?
I think we can get down to I think if you get rid of the cumulative stuff, you're really probably down to not a lot.
Right.
So that might be a good idea. What do you think about that?
I think you're right, Your Honor. I think that the issue became with the transcripts. Once you started taking her out, it became confusing. So she would actually ask a question and he would answer it.
Right.
Or she would correct him on the restitution figure 3 times in a row. So then he's just shouting numbers out and it doesn't make sense. So a lot of it was just confusing with what was being proposed. So we're trying to go back and be more strategic about this.
All right. And so my goal is to make things clearer and easier for the jury
Yes.
than confuse them. And so to the extent that you're having that situation where there's a question that she's asking that he's answering, and it's cumulative, the relative prejudice, I understand the argument, and I'm not ruling on it right now, Attorney Tipton, because once she's there for one answer, she's there, your argument is going to be the prejudice attaches. I understand the argument. But it's also incumbent upon me to provide evidence to the jury that they can, in a manner that they can consume it. And if it's doing so, once I balance the prejudice, in a way that allows them to digest the evidence. But I'll think more about the prejudicial issue. And maybe you can get, there really is not a lot that she says that he doesn't repeat. So how about Friday on that color coding?
Yes, Your Honor.
All right.
We've only got about 15 minutes left on this hearing.
That's all the motions eliminate, right?
Unless you got something else, people.
Yes, Your Honor.
All right. So, not much else that I have other than the jurors that were called in today were being used for a civil case. They're going to be told at the end of the day that they're being held over till tomorrow, and that's so that we will get a big yield tomorrow, and hopefully
big yield.
Both. I'm hoping to take 70 of the jurors tomorrow, and the remainder will go hopefully to Crim 2 so that they can get their work done too. And then every day they're going to be held over. So we will have jurors right through till Friday, because as you know, typically we don't get jurors on Friday. And we'll seek to 16.
So they will
Any
start jury
questions that you
selection
have
tomorrow.
lingering that you need answered between now and tomorrow morning on anything?
No, but I would ask to come to sidebar on an unrelated matter to this case.
Okay.
When the time comes.
Anything the Commonwealth
unrelated to this case
needs?
No, Your Honor. I think that we'll work together and try and figure out some of the other issues we've talked about today. I've been keeping a running list and just trying to make sure that we stay on schedule.
All right. I will see you at the side of the bench.
Okay, quick sidebar. Might wrap this all up. We were just on catch up, so we're a couple minutes behind. Let's see, make sure this is done. Beep, 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 beep. The sidebar continues. Does it look like they're even close to being done? No. It was all sidebar to wrap up for the day. Lots of beeps. More beeps. Sorry, they were just staring at the side of his face right now, so I'm just trying to find the end of the sidebar. I think that will, in fact, wrap this one up here. Beep. I think he turns around. There we go. There we go. Get a look at the defendant there.
So the plan is we'll see each other. We'll end today's work. I appreciate the commitment to do some further work on issues, but I think we're really in pretty good shape.
Yes, Your Honor.
As we move forward to the start of this. I will get you later this afternoon the most, what I believe is the most updated witness list, which will be attached to that supplemental questionnaire. Take a look at it carefully, and I made some changes, some other minor changes that you'll see in there.
And I think we'll be able to give the court the binders of the internet stuff with spreadsheets of the isolated ones that we're looking at.
All right. That sounds good.
Thank you, Your Honor.
Have a good day, and we'll see you back here at 9 o'clock tomorrow morning.
You as well, Your Honor.
Thank you.
At 9 o'clock tomorrow morning.
November 18th at 9 a.m. Thanks, everyone.
We are not going to be back here at 9 o'clock tomorrow morning because jury selection is not something we're going to watch for a week. Even if it is allowed to be broadcast, which I don't think it is because it's doing it individually instead of a panel.
No?
So.
Let's think about it.
Okay. I like the keep it simple method.
Blows a kiss from the mom. And dude in the black jacket doesn't even follow with his eyes. Interesting. Interesting. It's going to be spicy. It's going to be spicy. I'm excited about this one. Now, jury selection starts tomorrow. It will take possibly a week. They've got a week slated for jury selection to find the jurors and the alternates. The evidence in the trial is not scheduled to begin until December 1st. So this was the final pretrial hearing. And from there, they're moving on to evidence at the beginning of December. Yes, that was his mom. She was asked to leave at one point. She was asked to leave the courtroom, but she did return following the discussion about her. But I'm giddy over this trial. I don't know why. I did not know it was going to have binders of prawns. Binders of prawns, if you know what I mean. So hopefully search terms are tame, and they only admit what they need to for the case. The delicate discussion they had there in the middle that the female defense attorney was raising was basically suggesting that some of these search terms, instead of being evidence to support an accusation of murder, were actually just him searching for something he fantasized about. Yeah, so prawns and corn in the trial. And apparently throuple and everything else. So we'll cross that bridge when we get there. But wow, what a trial. All right, it's okay to be confused. I would be confused as well. We're going to use the shrimp analogy. Yes, we're going with shrimp. It's just a regular Monday. Love it. All right. Give me a minute. We have a case started this morning that we might go down and watch. I don't know. I never heard how long the case is slated to last. And I don't want to have one that lasts too long, but I think this is another. Here's why I don't like it. It's open and shut. It's in Georgia. It's a what possible defense could you have type situation. At least for my first take on it. But all you can eat shrimp counter. Shrimp cocktail. Yes, I see all the references. Wildcats. My understanding is it is pool camera. I think NBC 10 is pool on this one. That's the cameraman. I can tell you, the individual operating the camera is a news footage cameraman. This is somebody who films for the evening news on a daily basis, and I know that because of the shots he's getting, the style of shooting with the pan up, the slow reveal from the chair, exposing that, the zoom in on the notebooks. That's what's called B-roll. B-roll are the video clips that are played while the anchor is talking. Sometimes used with an SOT and things like that. But anyway, shrimp tacos. Yeah, all the shrimp are coming in. So apparently it's in season. It was awesome to be on Uncle's stream. I'm amazed by what he leads and what this community does. It's absolutely amazing. That particular children's hospital is not one that I have personal experience with, but in my own family, we have had occasion to go to a children's hospital, and seeing the work they do and seeing the way they do it is I don't know how you can walk out and not have your heart touched by just what an awesome role they fill and how they do it in the medical world for kids that are going through things that are, adult-sized problems with little children, especially health-related, it's amazing. So, all right, I'm going to stop with all the shrimp references because apparently I chose the wrong word. Maybe I need something else. He is at 98,000. He's going to get to 100,000. He's right now in 4th position. He'd have to get like 7,000 more in 7 or 8,000 more in donations to pass the 3rd position person right now. And then there's no way he's passing 2 and 1 because they're in the millions, and they're massive, massive companies. So I imagine he'll be at 100,000 here within a week. So it's just super amazing to everyone who was able to donate in a big or a small way. It was awesome. All right. Let me see if we can find where we're going next. Hold on just one second. Hold, please. It's taking a second. Here we go. Hang on. Michael Trowbridge, thank you for all you do for us. Thank you very much. 23 months of support. You're about to get a new color of courthouse on the jury as well. Absolutely amazing. Thank you, Michael. Wouldn't be the same without you here, and glad I can do what I can. Love to be able to help out with the audio when we can, just to make it better. That particular Brian Walshe thing, I've got a trick for that one that enables me to really get rid of a lot of the background noise. So that is wonderful when we can do that. In the meantime, let's see if we can jump down to Georgia and see what's going on in this. I would call it an open and shut case, but I shouldn't give it away that way. Yeah, it's going to need some audio work as well. Let's see what we got. And we're on catch up here, so we've got to speed it up. Just 1 second. We've got to speed this up, or else we'll never catch up. Speed 1.25. Okay. There's our defendant. If you can't tell him, he's the one in the brighter colored clothing, not the power tie, which looks suspiciously like Mr. Yannetti's, I might add. Audio needs to be in both ears.
Good morning, everyone. I am Judge Sonia Brown. I'm the presiding judge for this jury trial calendar for Monday, November 17th at 9 a.m. Position 1, Matthew Scott Lanz. Good morning. Good morning, Judge. Okay, I just need to call. I have a couple things on the calendar, so just want to make sure you're all ready. Okay, thank you. Position 2, Jamarcus Blackman. Okay. Is Mr. Blackman or Mr. Willingham present?
Okay, she's calling some other cases as well. Hold on just 1 second. We're gonna zip ahead because we don't need all that.
Okay, thank you. And periodically we will have sidebars and bench conferences that we need to have conversations outside of the presence of those in the courtroom. Attorney Berry, do you waive Mr. Lanz's presence at those sidebars and bench conferences, and then with the stipulation that you will communicate to Mr. Lanz what is discussed during those bench conferences? Okay, thank you. All right, for those who are present in the courtroom, I do want to remind you, one, that there should be no audio and video recordings or pictures taken during the course of these proceedings, unless, of course, you have received consideration and permission from the court, such as the media, to use audio or video recordings or pictures. For those who are on Zoom, I do want to remind you that this still is a court proceeding, and the rules of the court also must be followed for those who are on Zoom. Zoom is a courtesy to those who are viewing, and so you are to also be reminded there should be no audio or video recordings, nor should any pictures be taken during the course of these proceedings. Also want to remind those, unless you are an officer of the court, a staff member of the court, law enforcement, or again, media who has permission, all phones should be turned off. Not on vibrate, off. And the reason I ask that is we want to ensure that there are no interruptions during the course of these proceedings, and the court, as well as the attorneys, are able to hear everything that is being communicated. If you need to take a phone call, if you need to text, I do understand that life does not stop because we are in this courtroom. I do ask that you please step out, take whatever phone calls or text messages that you need to do, and then you can come back in. Also want to remind everybody that while I recognize that this is in a very emotional time and this proceedings can cause some emotions to be felt, I do ask that you try to contain them as best as you can while in court. If you get over emotional, that is okay. But I do ask that you please step outside until you're able to compose yourselves and be mindful that there is court going on in other courtrooms on this floor. And so once that is done, you can always, of course, come back in. We're more than happy to have you come back in and rejoin us in the courtroom. All right. Yeah, no, we're ready to proceed. There are a few things that you all said that you need to enter on the record, but we do need to have the indictment and have Mr. Lanz enter his plea before we begin and join issue.
That's correct. We do have some stipulations. Okay. Read those in the record.
We will. I just want to make sure everything is signed and issue is joined, and we'll proceed with the stipulations in just a moment.
All right, we're doing what we can on the audio here, trying to take some of the hum and the buzz out of there, but it's right in the middle of the what I call the vocal spectrum.
We are here today to try the case entitled The State of Georgia versus Matthew Scott Lanz, the defendant having freely, voluntarily, and intelligently waived his right to a jury trial and having been advised by his attorney of the rights that he is giving up and the possible consequences, has requested a bench trial in which the court will decide the case and determine the verdict of guilty or not guilty. The defendant, Matthew Scott Lanz, has been indicted by the grand jury of Cobb County in an indictment that is composed of the following counts. Count 1, malice murder. Count 2, malice murder. Count 3, felony murder. Count 4, felony murder. Count 5, felony murder. Count 6, felony murder. Count 7, home invasion. Count 8, aggravated assault. Count 9, aggravated assault. Count 10, possession of firearm during commission of a felony. Count 11, possession of firearm during the commission of a felony. Count 12, cruelty to children in the second degree. Count 13, tampering with evidence. To this indictment and the counts that I've just read, the defendant has pled not guilty and denies each and every allegation therein. This is what forms the issue that is to be tried. And again, there are stipulations that you all would like to put on the record and any other procedural concerns or issues that the court needs to be made aware of.
Sure, if we can approach on one matter.
Yes.
That'd be great.
Okay, while they approach, let me explain a couple things. Because we have no jury, there are no jury instructions. That makes it much quicker, much quicker. It also means that that some objections should be able to be argued in court, in open court. If it's something that we can hear as a public, but the jury would not be able to hear, we can hear it. The judge would hear this anyway. The judge will decide this case. The defendant is in jail clothes, because the judge is able to separate the fact that the defendant is in jail clothes because he's in custody pending his trial, whereas the jurors, for some reason, are not able to do that. So we will see him in jail clothes. Lots of people in this one. This is a very, very difficult case. He's accused of killing, thank you, Red Pen, he's accused of killing his neighbors, husband and wife, and leaving their young child for 12 hours on his own. So there's a lot of murder charges on there. It's for 2 people. Those are basically like the lesser includeds that you see on there. So he'll be if he's convicted, he'll be found guilty at 1, and it will sort of fold the others in, or they'll disappear. Bench trial is my new favorite. Did he choose a no jury? Yes, he waived his right to a jury trial. Everyone has the right to a jury trial, which is why we see some cases where we're like, why in the world did this go to trial? Well, because the defendant has the right to say, I'd like a trial by jury. And in most cases, they can do that. So let's see. Remember this in the news from Georgia. This did take a while to come to trial, mostly because there were questions about the defendant's mental competency. And we're going to zip ahead because we can here, so give me just a second. All right. We are catching up. Don't know if I've ever seen a bench trial. Oh, they're wonderful. I think you'll love them. There's no guessing what the jury's thinking because it's the judge, and sometimes you get a little peek inside their thought process.
Are there any witnesses who are present in the courtroom? Because I will be invoking the rule of sequestration, and so all witnesses should remain outside of the courtroom except when you are personally called to testify. And additionally, all witnesses should not discuss the case with any other witnesses or parties until the evidence is concluded or the witnesses individually all of them have been excused from further appearance. You are permitted, however, to discuss your testimony with the attorney in this case. In counsel, I will remind both the state and the defense that you are to instruct your witnesses of the requirements of the rule of sequestration in this case.
Your Honor, we are asking for an exception for the lead detective in this case, Detective Zachary Stanner, who's seated at counsel.
That's standard.
Any objection? Okay. Detective Stanner, you are able to remain in the courtroom. All right. In stipulations?
So, Your Honor, we do have written stipulations here. They are labeled stipulations 1 through 9. Both myself and Mr. Berry have signed the stipulation. Okay. There are some state's exhibit numbers that are blank right now because we have not pre-numbered all of the evidence in this case. So we can go ahead and provide this to Your Honor. We don't need to read any of them into the record at this time, and we will update those missing numbers as we progress.
Okay, thank you. Attorney Berry, you have an opportunity. This is the...
We looked at those and several others we had to work on.
Okay.
What we'll do is once we got the exhibit on the
Okay, thank you. All right, state ready to proceed?
We are, Your Honor.
Right. Defense ready to proceed? Okay, state, we're now ready for the opening statements. You may proceed.
Unplug your computer. And he just talks to the judge. See if they mess up and say jury in this one.
September 5th, 2021. A momentous day in this young couple's life. They did something on this day that most young relationships can't do these days. Justin and Amber Hicks bought their dream home. And on this day, they moved into that home at 5059 Robina Drive here in Cobb County. They bought this home just days after their son Jacob's birthday. But 73 days later, 73 short days in their achievement of this home, on November the 18th, 2021, a family's worst nightmare came true.
Chihuahua Mama, welcome to the
you guys have called them on their phones and they didn't answer.
We've tried calling multiple times now. My brother's phone rings a few times if we're going to voicemail. My sister-in-law's phone immediately goes to voicemail. According to my mother, they've been off social media for about 12 hours now.
The morning of November 18th shattered this family. November 18th, not only was this family shattered, but so was the back window of that house. And that is what they found. But we got to go back just a couple hours. November the 17th, 2021. On this day, it was a day just like every single other day for Justin, Amber, and Jacob. They had come home that night like any other day. Justin and Amber got Jacob ready for bed, got him fed, cleaned up the house, and put him down for the night. In this home that they are finally moved into and enjoying, Jacob and Amber are cuddling up on the couch. Jacob is upstairs sleeping in his bed. Amber watching the baby monitor to her side. They sat on this couch to watch TV and enjoy the night. But what the Hicks didn't know is that on this night, there was someone lurking on the outside of their home. They had just recently put up this Christmas tree. This Christmas tree was right next to the living room, connected. What they didn't know was that there was someone outside looking at this Christmas tree. And around 10 p.m. that night, this family's worst nightmare came true. Around 10 p.m., the back window of their home was broken into. The Hicks were unaware. They were defenseless. They were executed. All while Jacob was asleep upstairs. This is the state of Georgia versus Matthew Lanz. Now, you've read out the charges right before I started opening, but I do find that it's important to go through those charges as we put up evidence through this case during this week so that you know what to look for. Now, count one in the indictment is malice murder. This is did unlawfully with malice of forethought cause the death of Timothy Hicks, a human being, by shooting Timothy Hicks with a firearm. Now, just for the court, Timothy Hicks is the legal name of Justin Hicks. It's Timothy Justin Hicks. He just went by Justin, but that is his legal name. Count two, malice murder did unlawfully with malice of forethought cause the death of Amber Hicks, a human being, by shooting Amber Hicks with a firearm. Count three, felony murder while in the commission of a felony, to wit, home invasion, as set forth in count 7 of this indictment, did cause the death of Timothy Hicks, a human being, irrespective of malice. Count 4, while in the commission of a felony, to wit, home invasion, as set forth in the count 7 of this indictment, did cause the death of Amber Hicks, a human being, irrespective of malice. Now, this is count 7, which those two prior counts are predicated upon, which is this home invasion, did unlawfully without authority and with the intent to commit forcible felonies therein, to wit, murder and aggravated assault while in possession of a firearm, to wit, a handgun, a deadly weapon, enter the dwelling house of another, to wit, the Hicks residence located at 5059 Verbena Drive, Northwest, Ackworth, Georgia, while it was occupied by Timothy Hicks, Amber Hicks, and Jacob Hicks, persons with authority to be present therein. Now, jumping back to count 5, this is another felony murder count. While in commission of a felony, to wit, aggravated assault, as set forth in count 8 of this indictment, did cause the death of Timothy Hicks, a human being, irrespective of malice. Then count 8, in which that is predicated upon, aggravated assault, did make an assault upon the person of Timothy Hicks with a firearm, a deadly weapon, to wit, a handgun. Count 6, felony murder, while in commission of a felony, to wit, aggravated assault, as set forth in count 9 of this indictment, did cause the death of Amber Hicks, a human being, irrespective of malice. Then the predicated count of count 9, aggravated assault, did make an assault upon the person of Amber Hicks with a firearm, a deadly weapon, to wit, a handgun. Count 10, possession of a firearm during the commission of a felony, did unlawfully have on and within arm's reach of his person a firearm, to wit, a handgun, during the commission of murder, home invasion, and aggravated assault, felony crimes involving the person of Timothy Hicks. Count 11, possession of a firearm during the commission of a felony, did unlawfully have on and within arm's reach of his person a firearm, to wit, a handgun, during the commission of murder, home invasion, and aggravated assault, felony crimes involving the person of Amber Hicks. Count 12, cruelty to children in the second degree, did with criminal negligence cause Jacob Hicks, a child under the age of 18 years old, cruel and excessive physical and mental pain by leaving Jacob Hicks' parents deceased in the home with said child, resulting in the 2-year-old child being alone and unsupervised for approximately 12 hours, during which Jacob Hicks was unable to feed himself, change his diaper, or get the attention of his parents, causing him excessive physical and mental pain. Count 13, tampering with evidence. Did knowingly conceal physical evidence, to wit shell casings, said evidence involving the prosecution of the offenses of murder, home invasion, and aggravated assault with the intent to prevent the apprehension of and obstruct the prosecution of said accused. To wit, said accused did remove shell casings from the murder scene so as to avoid apprehension and otherwise obstruct the prosecution of himself.
There's
now
a little buzz,
the counts in
and I can explain it,
moving forward,
but it's not easy to remove.
Those are the elements that the court is defined. But I do find that it would be helpful that we kind of put in front of the court a roadmap of who we're going to hear from, what we're going to hear about, and so forth. So I'd like to introduce you to the parties. This is the Hicks. This is Justin, Amber, and Jacob. To the left, we have Justin Hicks. As I previously stated, Justin's full legal name is Timothy Justin Hicks, but he went by Justin. Throughout this trial, we'll be referring to him as Justin. He was 31 years old at the time of his death. He was married to Amber Hicks. He had one son, Jacob Hicks, and he was a Cherokee County firefighter. Then here on the right, we have Amber Hicks. She was 31 years old at the time of her death. She was married to Justin Hicks. She had one son, Jacob, and she was an audiology assistant. And then we have Jacob Hicks. He was 2 years old at the time of his murder. He's 6 now. He was home at the time of the murder. He was alone within several hours as their deceased bodies were within that home. And you're going to hear evidence that Jacob tried to cuddle with his parents as they lay deceased on that couch. You will hear and see evidence that Jacob tried to play with his parents with toys, as you will see toys on Jacob, or Justin. During that time, you will hear that Jacob had no ability to get the attention of anyone. He had no ability to get food or water or change his diaper. As I previously stated, the Hicks moved into 5059 Urbana Drive on September 5th, 2021. For the court, I have a visual map, which the location of these homes is very important. Now, the Hicks residence is located here on Menandra Way and Verbena Drive, the corner there circled in yellow. Now the defendant, Matthew Lanz. He was 22 years old at the time of his murder. He's now 26. Throughout this trial, you will hear about his family, and you will hear interviews of several of his family members. His father is Scott Lanz. His mother is Teresa Lanz. You will hear about his older brother, Austin, and you will also hear that he is deceased. You will also hear that he has 2 additional sisters. The defendant grew up at this home at 600 Delphinium Boulevard, where he lived with his parents and all of his siblings. Now, back to the map where we've already indicated where the Hicks residence is. Here on this map, you can see the defendant's residence is right behind the Hicks residence. It's important for the court to know that the backs of these houses are actually facing each other. So if you would walk out the back door of the Hicks residence, you would be looking at the back door of the defendant's residence. You're also going to hear that the defendant was a University of Georgia student. He had an apartment up there. It was located at 435 North Church Street, apartment 4, Athens, Georgia. You are also going to hear that the defendant drives a 2008 black Lexus GS 350. Now, having that little understanding as to these parties, I'm going to go through the timeline as to the events that you're going to hear about. So we're going to go to November 17, 2021. You're going to see numerous surveillance videos throughout this trial of surrounding residents. Here at 7:09, you will see surveillance video of the last known footage of Justin, Amber, and Jacob. This is the last known footage of Amber and Justin being alive, and that's at 7:09 p.m. You're going to hear that the defendant gave an interview in this case, and you will hear that the defendant admits to driving from his Athens apartment to his 600 Delphinium home, the Lanz family home, that night. And just for a quick reminder, that is right behind the Hicks residence.
Not a long drive.
You're going to see some additional surveillance video footage of surrounding residents of the Lanz and Hicks residence. You are going to see that at 9:20 p.m. on November 17, 2021, the defendant drives his black Lexus towards the direction of his home. And that is towards his home. And you are going to hear during the defendant's interview that he admits to parking at his house at the 600 Delphinium residence, where he parks in the driveway, and then he admits to going into the backyard, kind of walking around, and smoking a cigarette. You will hear that the defendant admits that he never enters inside his home. He only stays outside of the 600 Delphinium house. Now, to just preface some of these surveillance videos, they are incredibly difficult to see because of how dark they are. However, you will hear from Detective Smith in this case, who is going to walk through these videos and show you where to look as to where you can see the defendant walking from to and from his residence to the Hicks residence. So between 9:31 and 9:32, it can be seen the defendant walking around the rear and side of the Hicks residence. Now at 9:32, you will see the defendant walk back towards his residence. And like I said, as this plays, it is difficult to see, but as the evidence is presented to the court, we will point you to where to look.
Yeah, this looks like Ghost Hunters. I can't see a thing on there. The problem with getting rid of the little hiss is it's oscillating. So it's going,
you will actually see the defendant again walking the property line.
I'd have to take out that whole section, which is where people's voices are as well. And it would sound terrible. So.
Now at 9:55, you will actually see in this video, as soon as I press play, you will see that a light turns on. At 9:55, you will see the exterior mounted motion sensor light connected to the Hicks residence at 9:55 p.m.
Bing. I saw that one.
Now this light is located right where that window is that I previously told the court about. Now about 15 minutes later, you will see surveillance footage of the defendant actually leaving the residence away from the Hicks residence. You will hear that the defendant then drove from his 600 Delphinium house back to his apartment in Athens. It's about an hour 45 to 2 hour drive. You will hear that the defendant admits to driving back from his family home to his apartment in Athens. You are going to hear that the defendant's phone was seized when he was taken into custody. A Celebrite extraction was done of his phone, and it will show that between the times of 10:16 p.m. on November the 17th to 12:43 a.m. of November the 18th, so leading into the next morning, his phone was placed into airplane mode. So while the evidence is going to show on his way back to Athens, his phone was in airplane mode.
Especially if that's the only time
which
it's ever
leads us
been
to
in
November the
airplane mode.
18th, 2021. On that morning, 9:34 a.m., that is when police received a 911 call for a welfare check, trying to get in contact with Justin and Amber. You will hear on that 911 call of a broken window on the back side of the house. And it's there that's when this investigation began. You are going to see body camera and photos of this home. And when officers arrive, this is what they find. They find this broken glass of the back window of the home. Inside, you can hear a dog and you can hear Jacob kind of making some noise on the inside. Now, there is no response with Justin and Amber. You will watch the body camera footage as Officer Brown makes his way, as he's the first officer inside the home. He makes his way into the home where that Christmas tree is. As he looks inside, he sees little Jacob peering around the corner, hiding. Officer Brown will testify that his priority was him, Jacob. He picks up Jacob and gets him out of there. You will hear that Jacob was covered in blood. He was wet. and he had a dirty diaper. It's here in the living room. Officers find both Justin and Amber deceased here in the living room. You can see that Christmas tree just right behind them. Crime scene was able to find and locate 3 9mm casings and 2 projectiles. You will hear about more projectiles, and as you hear from the medical examiner, but on scene, that is what's found. You're going to hear that there was 5 gunshot wounds to Justin and Amber, where those gunshot wounds were the cause and manner of death for both Justin and Amber. Shortly thereafter, the 911 call and the investigation began. As investigations take hold, officers and cars are all around this location of the Verbena house, the Hicks household. Around 12 p.m., Teresa Lanz, the defendant's mother, finds out about this murder. Teresa Lanz then goes from the 600 Delphinium house up to the defendant's apartment up in Athens. You will hear that Teresa Lanz arrives to the defendant's apartment around 2:30 p.m. on November the 18th, 2021. You will hear that she found the defendant sleeping at 2:30 in the afternoon and would pound on the door to try to get his attention. When the defendant would then come to his mother at the front door, he was in possession of a firearm. You are going to hear from Scott Lanz in an interview that shortly after Teresa Lanz got to the apartment up in Athens, he would then arrive. He also found the defendant having a firearm. You're going to hear that Teresa and Scott took that firearm from the defendant in a .40 caliber magazine. They would then leave the defendant at his apartment and drive back to the 600 Delphinium.
You said a .40 caliber magazine?
You are going to hear that the defendant admits that his parents came to his apartment in Athens and that they took his gun from him.
A 40 round magazine?
Shortly after that, on November the 18th, later that night, officers are actually executing a search warrant of the Lanz household. That is where Teresa and Scott are at the house, and you will hear that Scott tells police, "I took a gun from the defendant and I placed it inside of the house. It's located in a sports coat pocket upstairs in a closet." Officers would then search the house where they would find a Zev OZ 9mm pistol in the upstairs closet in a sport coat jacket. You are going to hear about a DNA examination of that Zev OZ 9mm pistol. You're going to hear from forensic biologist Ted Bill with the ATF that he conducted a DNA comparison of swabs of the pistol to that of the defendant. You are going to hear that the DNA profile of the swabs of the pistol are consistent to that of the defendant. You are also going to hear that there was a firearm examination done of this firearm. And you are going to hear from firearm tool mark examiner Vanna Kelly with the ATF, where she was sent the 3 casings that were found on scene, and then conducted test fires of the Zev OZ 9mm that was sent to her, and compared those 3 casings to the test fires that came from that Zev OZ 9mm.
It's a pretty expensive firearm.
That the casings that are found on the scene were fired by this Zev OZ 9mm pistol.
They run about $1,700, $1,800.
Now back to November, or the timeline, November 19th, 2021. You are going to hear around 9 a.m., 90 Cameron Glen Drive in Sandy Springs, Georgia. You are going to hear about a 911 call of a burglary in progress. You are going to hear that Sandy Springs police officers arrive to that residence and they find the defendant inside the home, upstairs in this home. You are going to hear that the officers enter that home and command the defendant to come down from the upstairs. You are going to watch the body camera footage of this interaction with the defendant. After several minutes of commanding him to come down, the defendant would make his way down the staircase, dressed fully in camouflage, several layers with a mask and a fishing hat. You will then watch as the defendant, as soon as he hits that bottom step, attacks one of the officers there. You will see and watch that the defendant then stabs the Sandy Springs sergeant in the back of the neck multiple times. It is at this point that officers then shoot the defendant twice. They shoot him in the neck, in the right upper chest. You will watch the defendant be taken out of that home and into the front yard where he was subdued, he was tended to, taken to the hospital, and then into custody.
Yeah, that's hard.
Now, I want to talk about the three main pieces of evidence that you're going to hear about, and really they're just categories of evidence. Those three pieces of evidence are digital evidence, statements, and forensic evidence. What I mean by digital evidence is really the evidence that puts the timeline together. The surrounding surveillance videos of homes surrounding the Hicks and the Lanz residence that show the defendant's arrival, the departure, and then in addition to the defendant's phone extraction being placed in the airplane mode. You're also going to hear about Justin and Amber's phone extraction, which show their last known activities. Now, statements. The defendant's statements to law enforcement, Scott Lanz's statements to law enforcement, and Teresa Lanz's statements to law enforcement. And last, forensic evidence. This is the defendant's gun. You're going to hear that he is the rightful owner of that gun. He had bought that gun. You're going to hear that the defendant's DNA is on that gun, and the casings that are recovered on scene were fired from that gun. Now, some expectations as we move through this week. There's no video of the murder itself. There was no video on the living room of where this murder occurred. But with the surveillance videos and the circumstantial evidence, we were able to provide that timeline to the court. There are 2 missing casings from the crime scene, because you will hear from Dr. Ashraff that they were shot. There were 5 shots, but there are 2 missing casings. As I previously stated, the surveillance video in the front of the Hicks household is incredibly difficult to see because of the dark nature. However, Detective Smith will show and point where to look at the appropriate times. There is no perfect timeline. There never is. But we will present a timeline for the court to make the findings that we need to make. The defendant's statements during these interviews are odd at times, and you will not hear a specific motive in this case. Now, as the court knows, my duty is that the burden is on us. It's always on us. The burden of proof is always on the state to prove every criminal case as to each essential element of the crime charge, beyond reasonable doubt, and that never shifts. Now, your duty this week is to listen to the evidence and ascertain the truth. What I mean by that is that I ask the court to look at the 5 C's. That's the corroboration of the evidence, consistencies and inconsistencies in the evidence, the credibility of the witnesses as they take the witness stand.
He sort of preaches to the choir here.
And last, just common sense. At the end of the evidence, we will ask that you return a verdict that speaks the truth. There is only one truth in this case, and that truth is that the defendant is guilty to all counts of this indictment. Thank you.
Thank you. Thank you, Ayden Horowitz. Attorney Barrett, would you like to make your opening statement at this point?
It's very short.
Okay, you may proceed.
He used his jury presentations on the judge. A little bit of
The object
overkill.
of all legal investigation, obviously, is to seek the truth. This is a very emotional case, very difficult case, as the court pointed out earlier. As the court already knows from your experience, the state has the duty and responsibility of proving the case beyond a reasonable doubt. And of course, what they say in opening is just what they allege the evidence to be. We'll have an opportunity to test that evidence and talk about it. Matthew believes that he has been set up either FBI, CIA, or some government agency. I think you'll hear some information about that through the statements. We'll have the ability to listen to those and evaluate those. We believe that, and certainly are confident that the court, after you hear all the evidence in the case, will be able to make an enlightened and fair judgment as to the guilt of Matthew. We'll have an opportunity to come back before the court and talk about what the state's case has proven or not proven. Thank you.
Thank you, Attorney Barrett. State, make call your first witness.
State calls Timothy Hicks.
This would be the father of the victim. The cameraman is positioned in the jury box because there is no jury. The judge will be deciding all the things in this case.
You do solemnly swear or affirm the testimony you're about to give the court on the issue now pending shall be the truth, the whole truth, and nothing but the truth, so help you God.
Have a seat for me, please. And once you're seated, if you would please state and spell your true and correct legal name for the record.
My name is Timothy Johnson Hicks, and TIMOTHY Hicks, HICKS, and I go by Tim.
Thank you.
Tim.
You may proceed, Ayden.
Thank you, Your Honor. And for the record, we have shown all exhibits to defense counsel. Tim, before you took the stand, did I show you this photograph, State's Exhibit 1?
You did.
All right, and who's in that photograph?
That's Justin, Amber, and Jacob.
Is that fair and accurate in-life photograph of Justin and Amber Hicks?
It is.
At this time, I would tender State's Exhibit 1 into evidence.
Any objection? No. State 1 is admitted.
May I publish this?
Yes.
Can't really fix that oscillating noise because it's oscillating so wildly. I can make it go away, but you'd lose a lot of the dynamics of everyone speaking.
All right, Tim, looking here at State's Exhibit 1, you said that it was Justin and Amber. Who is Justin Hicks?
Justin Hicks is my son.
What was his legal name?
Timothy Justin Hicks.
So not exactly a junior, but close.
Close.
And did Timothy Justin Hicks go by Justin?
He did.
How old was he at the time of his death?
At the time of his death, he was 31.
What did he do for a living?
He was a firefighter for Cherokee County, firefighter paramedic.
How long was he with Cherokee County Fire Department?
Before his death, about 6 years.
Did he wear any glasses or corrective lenses or anything?
He did. He wore glasses.
Did he wear them regularly or just at night?
Somewhat regular, but I think mostly for driving and reading and watching TV, things like that.
Who is Amber Hicks?
Amber's my daughter-in-law. She would be Justin's wife.
Did she go by Amber?
She did.
How old was she?
Amber was also 31.
What did she do for a living?
She was an audiology assistant at the time of her death.
Wonderful. How long were they married? Do you remember when they got married?
I believe the year they got married was 2017.
Okay. Do you remember the date?
April, maybe April 12th.
Does April 22nd sound right?
Yeah, that sounds right.
Okay, April 22nd of 2017.
Yes, ma'am.
So if I'm doing math correctly, were they married for about 4 years at the time of their deaths?
They were.
And then here in the photo, we also have this little boy. What is his name?
The little boy is Jacob Raymond Hicks.
When is his birthday?
September 4th of 2019.
Also, prior to taking the stand, did I show you State's Exhibit 3?
Yes, ma'am.
And did you recognize that photo?
I did.
And who's that photo of today?
Can I see it again? I know that I saw it. And
That's okay. State's 3.
that's Jacob.
Is this a more recent photograph?
It's not that old.
And is that a fair and accurate photo of Jacob today, one of the surviving victims in this indictment?
Yes, ma'am.
State moves to tender State's Exhibit 3 in evidence.
Any objection? State's 3 is admitted.
May I publish?
Yes.
So how old is Jacob today?
Today, Jacob's 6.
Where does he primarily live?
He lives with my wife and I, Charlene.
And your wife, is that Justin's dad?
No, Justin's mom.
Mom, I'm sorry.
Yeah, that's
Thank you.
okay.
Yes. Okay. I want to talk to you about 5059 Verbena Drive. Do you recognize that address?
I do.
And prior to testifying, did you see a photo of that residence?
I have.
Okay. Was that State's Exhibit 2?
Yes, ma'am.
And did you recognize that photograph? Had you seen it before?
Yes, ma'am.
How had you seen it before?
I saw it by Justin and Amber, and I believe at one time or another it was probably a Facebook post, and my wife and I both, I think, were texted a copy of it.
Is that a fair and accurate photograph of their residence at 5059 Verbena Drive?
Yes, ma'am.
State moves to tender State's Exhibit 2 into evidence.
Any objection? State's 2 is admitted.
May I publish?
Yes.
Is this the photo we're talking about?
Yes, ma'am.
Do you recall?
Oh, she can show you
Okay. Yeah, that's correct.
And do you recall the significance of this photo or when it was taken?
If I remember correctly, the photo was taken shortly after they moved in.
Was this kind of that obligatory first new home photograph?
Yeah, kind of.
Now that address, 5059 Verbena Drive, what is the city that it's located in?
Ackworth.
Is that in Cobb County?
Yes, ma'am.
Who kind of initiated the purchase of this home?
Well, Justin and Amber both saw the home and were looking together. And when they saw this particular home, I believe Amber kind of fell in love with it, and it was kind of the house that she wanted. And so that's the one they aggressively pursued.
Were they excited when they were able to purchase this home?
A whole lot.
This is a big deal for them?
Yeah.
Now, once they moved into this residence in September of 2021, did they decorate and furnish the house?
Yeah, they decorated and furnished it.
And did they keep it pretty clean?
Clean's not the word for it. I mean, Justin's a neat freak.
Okay. Immaculate, maybe.
Oh yeah, he didn't have a speck of dust or a crumb or yeah, he's pretty. I'm not saying Amber wasn't, but I know Justin was.
Did they typically, clean up and tidy up before they went to bed at night or relax?
Yeah, typically dishes were done, things were put away. In fact, they even, best I can remember, they prepared for the next day. Had like Justin would have his uniforms pressed or whatever and ready to go.
Diaper bag packed,
Diaper bag packed, and yep.
What about safety measures? Did they have their house baby-proofed for Jacob?
They did. Jacob's room, actually, Justin had turned the bedroom door into a two-way door, maybe like a barn door, where you could open the top or the bottom, and they'd open the top so they could see in, but Jacob couldn't get out without them knowing it. And they had a baby monitor. They had gates on the upper and lower end of the staircase. And if I remember right, they had a gate or two actually on the main level blocking something. And those gates were locking gates.
Gates are great for teaching your children how to climb.
I forget the kind of lock, but it was more or less a child-proof lock.
And do you know whether those child-proof locks were engaged when, typically when Justin and Amber were still awake at night, but Jacob had already gone to sleep?
If Jacob had gone to sleep and they were sitting up for a little while, the gates were most likely unlocked.
Okay. But they would secure them before
They
bed?
would secure them when they went to bed.
What about locks on, baby locks on like doors to the exterior?
They had some of those. They also had some of those little hinge things you put on cabinet doors and things like that. Plugs in the sockets and outlets and.
Really made a lot of efforts to keep that house baby-proof.
Yep.
Did they have a security system?
They did. I believe it was one called Ring. Was it Ring? That's what sounds. Or what I remember. I think it was Ring. One of them at the door, cameras, and you can see it on your cell phone.
Not a sponsor.
Kind of thing.
And do you know whether they had subscriptions where data stored for things like writing the footage?
I think they did. I think they had. I don't know who the alarm company was, but I believe they did have some sort of. They had some sort of system where it was recorded.
Okay. I want to direct your attention to November 17th of 2021. Do you remember that day?
Unfortunately, I do.
Do you remember what Justin was doing on November 17th of 2021?
On that particular day, he was off of work. My wife and I were babysitters for Jacob while they worked. And anytime Justin was off, he kept Jacob himself. So I knew that he was off because Jacob was with him. And I'm not sure what all they did that day. Hang on, let me gather my thoughts back.
Well, let me ask you this. So Justin and Jacob were home that day.
On the 17th. Yeah, I'm trying to get the date between 17 and 18. Right.
It's okay. What kind of car did Justin drive?
Justin drove a black F-150 pickup truck.
And did Amber have her own car as well?
She did. She had a Chevrolet Equinox.
And do you know on November 17th of 2021, were both of their vehicles home?
No, that particular day would have only been Justin's truck because they had gone the night before. they dropped it off at a mechanic. It needs some sort of repairs, and so they had dropped it off and met up at some point, and would have all been in Justin's truck.
Did anything, for the time that you had contact with them on November 17th of 2021, did anything seem off to you?
Everything seemed fairly normal.
And now I want to talk to you about November 18th of 2021. Do you remember that day?
Yeah, that's where my memories mostly, that's where I'm drawn to, trying to answer questions about the 17th.
Why is it that your memory is drawn there? What happened on November 18th of 2021?
My wife and I were in bed asleep. It was early in the morning, and my phone rang, and it was Amber's work, her boss from work. And she had asked if we knew where Amber was. And I told her, no, we don't know what's going on. She said she hasn't reported for work. And I'm like, okay. And it's kind of like spiritual radar went off inside me, and I knew something was wrong. I'm personally a pattern person, and I just keep up with patterns. And I knew that she should be at work. Justin would be off with Jacob. And so I immediately woke my wife up, and I told her, if you're going with me, get in the van, let's go. And we drove to their house on Verbena. And we parked in the driveway, and I noticed first the garage, because that's where, when you pull in, the garage was, which we were facing, off to the left was the sidewalk that led to the front door. I ended up going to the front door, and I was banging on it very hard. And I gradually got harder and harder because I didn't get any response. And finally, I was banging on it so hard it was actually bowing a little bit. And I didn't hear the dog bark. I didn't hear Jacob. I didn't hear anybody. And so I have prior law enforcement experience, so I did go over there armed. And I kind of jumped into law enforcement mode, and I started searching the perimeter of the house. I left the front door and I went around to the left side of the house and was walking the edge of the wall all the way around, quick peeks and looking. And in the backyard, they have this little breezeway kind of thing, it's like a patio. And when I got to the corner of the house there, where that separates, I did a quick peek. And I saw that the blinds and curtains were flapping in the wind, and there's glass everywhere on the patio. I knew then there'd been some sort of forced entry. I approached the window. My intent was to go in. I approached the window, pushed the blinds back. And I looked in. The first thing I saw was a bunch of glass inside that room. That room that door and window enters would have been Jacob's playroom. And as I looked in there, I noticed there was lots of glass all on the floor. I peeked a little further and looked to the left. The left would have been their living room or den, or however you want to call it, their TV room, the couch and all of there. And as I peeked in, I saw them.
Take your time. Take your time.
I saw that they weren't okay. And when I saw that, I'd already kind of got into cop mode, and I backed out because I was the only one there, other than my wife and daughter, and they wasn't going to help me clear the house. That wasn't even going to happen. So I backed out the window, and I took a low ready position. I had my daughter call 911 and had my wife take the van out of the driveway, parking on the street, and I had both of them get on the opposite side of the van for cover. I didn't know if anyone was still in the house or not.
I want to stop you right there because I want to slow down just a little bit.
Okay.
Had you ever gotten a call from Amber's work before?
Never have. I have, but not on things like that. It was generally, I own a woodworking business, and they called a couple of times, want to help with some projects they're working on, but nothing out of the ordinary, like nothing that's a life-changing pattern. It was all other things.
So to your knowledge, had she ever just not shown up to work?
Amber never do that. If she wasn't going, she'd call.
Prior, I know you said you just got that feeling and wanted to get in the car immediately. Did you try to call Amber?
We did. We tried to call both their phones. I had my wife, I think maybe my wife and my daughter calling them as we were driving, or as I was driving.
And were you ever able to get any response from anyone?
No response on either phone. And that just intensified the whole unction. Something's not right.
Did you try texting as well?
Maybe. I don't remember for sure, but probably.
When you say that you all jumped in the car, so who was driving?
I was driving the van. And
who was in the front with you?
My wife would have been in the front seat and my daughter in the back.
And who's your daughter?
Ashley Hicks.
And so Ashley and Justin are brother and sister?
They are.
Who's older?
Justin would be older. And then I have a son, Michael. He would be next, and then Ashley's the baby.
So you mentioned that you have prior law enforcement experience. Where was that?
In Cherokee County.
How many years?
Just right about 15 years.
And so when you originally arrived there, where did you park your vehicle or the van?
When I first pulled in, I pulled straight in the driveway beside Justin's truck.
And so your car was basically right next to him at the parking spot?
Right next to the truck in the driveway. The truck would have been to my left as I pulled in.
And when you said that you went to the front door and you were kind of pounding on the door, were your wife and Ashley next to you, or did they stay in the van?
They got out. They wasn't quite up to the door yet. They never really moved too much out of the driveway until I got to the back. And then Charlene just kind of peeked around the corner. And that's when I told her, I said, get back. Move the van out to the street. And actually, you call 911. And then both of you get on the opposite side of the van and stay down, hunker down and stay there.
Your Honor, at this time, State moves to tender States Exhibits 4, 5, and 6. States Exhibit 4 is the business record certificate from Cobb County 911 Communications. States Exhibit 5 is the 911 audio recording of Ashley Hicks, and States Exhibit 6 is the CAD report. Both the audio and CAD report are covered by the business record certificate in States 4.
Interjection? 4, 5, and 6? States 4, 5, and 6 are admitted.
And Your Honor, can we go ahead and publish States Exhibit 5? Yes.
See, I might be able to slow this down here just so we can hear the recording.
Now, what's the location of your emergency?
Hi, I'm here to report a break-in.
What's the address?
That is the address. 1 second, ma'am. What's the address? $5059 Verbena.
359 Verbena?
5059 Verbena.
Okay. And what is your name?
We need someone here immediately.
What is your name?
Ashley Hicks.
Your
My brother
number?
and his wife and a 2-year-old son are missing.
What's your telephone number?
679.
You guys don't need that?
79.
86753.
Tell me what's going on.
What, ma'am?
Tell me exactly what has happened.
So, my sister-in-law's work called saying that she hasn't called in today and it's out of character for her. So we stopped by their house and investigated the area trying to see if they made a tip. And one of the windows in the back is broken.
There's a window in the back that's broken?
Yes, ma'am.
Have you guys gone inside the house?
No.
Okay.
My father's a retired cop, and he does have a gun with him for
But
defense.
you guys are waiting outside for the officers, is that correct?
Yes, ma'am. We are standing at the edges of the street.
All right, give me just 1 second. Give me just 1 second to type in what you said, okay?
Yes, ma'am. Verbena.
You said it was a back glass of the door or just a window?
The window, ma'am. We don't know if anyone's still in the house. The father's kept us all outside and away from the house.
A lot of people keeping their eyes on the defendant here.
All right, now I've got it in for dispatch. So you guys have not went inside the residence. And where did you say you were standing?
We're standing by the driveway.
Are there
kind of on the road? I am wearing a purple hoodie. My dad is wearing a gray sweatshirt. And my mother is wearing a black hoodie. Again, we are unsure if there's anybody still in the house. We currently haven't heard anything. But we haven't checked, so we're unsure.
Okay. Now, as far as the family, are there cars gone, or like normally would you see a car in a driveway and it's not there, or it is there?
There are typically 2 cars. My brother, his wife, and their son went to drop off his wife's car. So far, only the truck is here. And no one has heard from them so far in about 11 to 12 hours.
What's your brother's name?
Justin Hicks. Timothy Justin Hicks.
What's his wife's name?
Amber Hicks.
And how many children do they have?
Just one. He is a 2-year-old named Jacob Hicks. Jacob Raymond Hicks.
Okay. Now, as far as anything else with you guys looking at the house, I'm not asking you to go back down there. Do you see anything else that looks like it's been disturbed or that it doesn't look right?
Not that I could see. I went around the house with my father, and all we noticed was a broken window.
And that you know of, that window was not broken before?
No, ma'am. My father said for the police to get here now, or he's going to go in.
They're on the way. I would suggest that you stay there and wait for them.
He said EMT needs to get here too.
The what?
EMT needs to get here too.
Who's injured?
He said just in case. We don't know if anyone's still inside or not.
Okay.
We're now across the other side of the street. It's a neighbor's driveway. We're trying to stay away from the house.
And you guys have tried calling them on their phones and they're not answering? Is that correct? Ashley?
A lot of time, dispatch officers are given flack for what sounds like just taking forever to get the information. But oftentimes one dispatcher is radioing to give the information and enter it in CAD while another one is taking information.
Hey, we got disconnected.
I'm sorry.
It's okay. I just want to confirm that you guys have called them on their phones and they didn't answer.
We've tried calling multiple times now. My brother's phone rings a few times if we're going to voicemail. My sister-in-law's phone immediately goes to voicemail. According to my mother, they've been off social media for about 12 hours now.
Okay.
Do you know how long police will get here?
They're responding emergency. You guys just stay where you are.
Yes, ma'am.
That means they're coming, but sometimes they code 4 lights and sirens.
Yeah, she said they're responding emergency.
I've got 4 officers that are on the way. So you guys just wait there and let them check the home, okay?
Yes, ma'am. She said 4 officers are on the way.
You know Dad wants to go in. Some police dispatch systems are built so that as the 911 operator is taking the call, it starts assigning it. So even a robot voice that assigns
I'm going to stay on the phone
calls
with
out
you
the
until they
different
get there.
people.
That way you can let me know if you see anything or if anything changes. Okay?
The call pops up on their screen in their car, dispatching them to the call while the officer's still taking information. They keep adding to the notes as they're driving there. The officer's basically being updated as they're en route. So it seems like it takes forever, but in actuality, they're being incredibly efficient in time.
Yes.
They're coming emergency. They're running lights and sirens, and the sergeant is also en route. You guys just stay where you are, okay? I'll let you know when I show they're close.
Yes, ma'am. She said they're responding emergency. The sheriff is also inbound.
No, the sergeant.
He has listed the ETA.
They're responding lights and sirens. Just hold on.
She said they're responding lights and sirens. He's asking if you could radio them what their ETA is. He's a retired cop from Cherokee.
Dispatcher doesn't want to play that game. The dad probably...
1 second, I'm asking.
Yes, ma'am.
The dad probably has his firearm drawn as in the position of cover and watching the house, if I'm guessing. So he's not going to want to be on the phone with the phone in one hand and a gun in the other. That's why he's relaying the information this way.
Nothing yet. Ma'am, are you still there?
I'm still here.
One just pulled up. Cobb County, please.
All right, then you can let me go. They're there.
Okay, thank you, ma'am.
Bye-bye.
Bye.
Tim, was anyone found alive inside that residence?
Jacob was eventually.
What about any pets?
They had a dog named Bruno and a cat named Cat? Yeah, the cat's name was Cat.
The cat's name was Cat. That's
Bruno, the officers eventually brought Bruno and Jacob out of the house. I'd like, if you don't mind, I want to say that during that 911 call, I haven't told my wife or daughter anything about what I saw. I left it alone, and I guess my wife was kind of having unctions as well, and that's what you hear in the background, is her screaming out.
Is that why you went ahead and asked for EMT?
Yeah.
Okay, when your daughter said just in case.
When I saw them inside the house, based on my experience, I knew that they were gone and there was no bringing them back from what I saw. But yeah, I asked anyway.
And at that point, had you laid eyes on Jacob? Did you know whether he was
I did
alive?
not see Jacob at all. I was very concerned about it. Honestly, my first thought was that he had also been killed.
When you finally laid eyes on Jacob, was he crying?
He was not saying anything or crying. The officer that brought him out was a black officer. I think his name was Winston. I think. And he brought him out, and Jacob was basically catatonic. He had a blank stare on his face. He wasn't crying. He wasn't saying a word. He just hung in Officer Winston's arm like a sack of potatoes. And Officer Winston brought him over to my wife and I at the van. And normally when Jacob would see Nana, he'd just bubble up. He did nothing. He didn't acknowledge anything.
Had you ever seen him like this before?
Never had.
What was he wearing?
He was wearing pajamas, a long sleeve shirt and pajama pants, bottoms, and
thank you, Larley.
His pajamas had been covered in blood, and it was dried.
The blood was dried.
It was dried on his clothes, and it bled through to his skin.
Do you remember whether his pajamas were otherwise dry or wet?
He had on a diaper. I don't know how many times he'd gone in it, but it was heavy. I mean, he was wet for sure. I don't remember if he had number 2 or not, but he was wet more than once.
A heavy diaper is the way you described it.
A heavy diaper.
Did he have anything in his hands?
Yeah. He was clutching Justin's glasses. And he wouldn't let go of them. We pried them from his hand. And I believe, I don't remember for sure if it was me or who, but we ended up giving them to the detectives, the glasses.
Are those glasses that Justin would use to watch TV?
Yeah.
Now, developmentally, was Jacob a fairly normal 2-year-old?
Absolutely.
Was he attached to his parents?
Yes.
Did he often try to get their attention?
Yeah. Yeah, if he wanted something, he didn't have a problem trying to get somebody's attention to get it or whatever. Still don't. But
if his parents were on call or busy or preoccupied, would he get frustrated if he couldn't get their attention?
Yeah, he would keep pursuing.
Kind of like any 2-year-old.
Like any 2-year-old.
Do you know what time he woke up back around that time? Typically,
Typically, he would wake up probably between 6 and 6:30 in the morning. The habit, he woke up pretty, he kept steady with the pattern even when Justin was off and kept him. Mm-hmm. But the pattern is when Charlene and I would watch him, he would get up about 6:30, and Justin and Amber would get ready for work, and Amber would drop him off at our house to babysit for the day, and he was up by then, stayed up, usually.
And so typically when he woke up between 6 and 6:30 in the morning, would he have a diaper change?
Oh yeah, he would have his diaper changed.
Was he potty trained at all when he was?
Not then, no.
Now, was he able to change himself or put on his own clothes or anything?
Not then.
And so Justin and Amber would wake him up, change diaper, put clothes on.
Right.
Okay. What about feeding himself? Who typically prepared his breakfast?
Amber and Justin would occasionally, if Justin was off from work, and then usually he had breakfast when he got to our house.
Okay. Is that still pretty early?
Excuse me?
Is that still pretty early in the morning?
Yeah. By then there'd be 8 o'clock maybe.
Now, was he able to get anything out of the refrigerator or go into the pantry himself and make his own breakfast back when he was 2?
No, not then.
Able to get himself any water or anything?
No.
Now, by 10 o'clock in the morning, had he typically eaten by then?
Yeah, usually by 10 he'd had his food and probably a couple of cups of juice or something from a sippy cup.
Snacks?
Probably snacks, yeah.
Now, on that day, do you remember once he came out of the home, did he eat at all?
The best I know that he had not eaten since dinner time the night before.
Did you have him checked out by EMS?
The EMS was on the scene, and I remember it was a female EMT or paramedic. I'm not sure what her title was, but she was a medic. I knew that. And she stayed kind of close to us. And at one point, Jacob still hadn't come around. It took a few hours for him to even realize he was still in the world. And when the EMT lady, she was a little concerned and said, if he don't come around soon, we probably need to transfer him to the hospital. But before that took place, he did come around. It was almost like he'd woke up from a bad dream. He just like woke up and, Nana, you know.
After he had been with Nana for a long time.
She's holding him, yeah, but before that he didn't even move. He just laid there.
Now, did that behavior continue for some days after? Or?
Not that particular behavior, but a little quieter than the average 2-year-old maybe.
And y'all had watched him regularly, so
since he was 2 months old.
Okay, so quieter than you had seen him previously.
Yeah, he was kind of a little bit docile for several days after.
Did he have any cuts or anything on his feet or his hands?
I didn't notice any cuts or anything on him.
So you had mentioned that there was kind of blood on his PJs that had kind of soaked through even to his skin. Was any of that blood, best you could tell, from Jacob himself?
That blood came from the crime scene.
Now, obviously you spoke to officers on scene. Could you think of anyone in this world who would have wanted to hurt Justin and Amber?
I cannot think of one person that would be considered their enemy. I mean, both of them just easygoing, likable kind of people. Kind of when they walked in a room, kind of lit it up, and without being flamboyant, made their presence was known. It was just someone pleasant to be around. Often if you felt a little uneasy, they had this unspoken way of bringing about a certain amount of calm. And Justin, he takes after me. He's a jokester, so he's always joking about something and cutting up about something. And he and I would razz each other back and forth about something. We like to fish together quite a bit, and he's always competitive when we go. It's just the two of us, but you would think it was a Bassmaster Classic between us. It often was, but yeah.
Thank you so much. The defense may have some questions.
Might be appropriate time for a break. We've been going for about an hour and a half and giving Mr. You don't have any questions? Okay.
No questions.
Be released from the subpoena?
Yes, is there any objection to Mr. Hicks being excused and released from the subpoena?
No.
Okay, Mr. Hicks, you can step down and you can remain in the courtroom if you'd like. All right. Let's come back at about 10:45. We'll get started and state you can call your next
witness. We're going to skip ahead because we are behind.
Stand in recess.
So we're going to do a couple things. We are going to start up the high speed again. We slowed it down just for that. The tape and the testimony following it. But we're also going to skip ahead just a little bit. So it is about a 10-minute break that they take. And this all happens this morning out of Georgia, by the way. So Got noisier and buzzier. That was a normal speed. We're now at 1.25. Let's see if I can work on this audio. It's oscillating a tiny bit.
Just want to remind everyone, if you are on Zoom, motor vehicles should not be operated in any way if you are on camera. So just need to remind everybody of that.
You might want to turn your camera off.
Now, I can't stop you, but you won't see it, so y'all can make a decision. What y'all want to do?
Pretend you're in court.
I just don't want anybody getting hurt while you're watching the proceedings. And
yeah, we don't want to watch an accident live. Okay. I'm gonna.
And I also need to remind everyone who's on Zoom that their devices should
sound
be
out,
muted.
As much as I can.
You might want, if somebody does know, you might want to just tell them to go off camera, so you can listen but be off camera. Yeah.
Sorry, Your Honor, I had to run downstairs.
That's fine. Yes. Okay.
It's just so bad. The buzz is terrible.
All right, we are back on the record for State of Georgia versus Matthew Scott Lanz, 22-00922. All parties are present. Any agreement, you may call your next witness.
At this time, State calls Officer Matter.
Thank you. I apologize, Attorney 88 Warwick.
Okay, so this is with my fix, and then this is without. Off. I'm going to leave it on, but it's...
Raise your right hand, please. You do solemnly swear or affirm the testimony you're about to give the court on the issue now pending shall be the truth, the whole truth, and nothing but the truth, so help you God. I swear to God.
Thank you. Have a seat for me, and once seated, if you would please state and spell your true and correct legal name for the record.
All right, it's Matthew A. Brown, MATTHEWABROWN.
Okay, you may proceed, and for the record, there is no relationship between the court and the witness.
Thank you. Officer Brown, how are you employed?
I'm employed with Cobb County Police, sir.
And how long have you been employed with the Cobb County Police Department?
Since 2004.
Now, in what capacities have you worked for the Cobb County Police Department since 2004?
I worked the road for about 10 years. I was transferred to Special Operations DUI Task Force in 2014. I spent 5.5 years there, and then in 2020, I think January 2020, I went to the STEP unit, which investigates all serious injury and fatal crashes in Cobb County. The STEP unit? STEP.
And if you'll bring the microphone just a little bit closer, thank you. Now, since 2004, have you been post-certified?
Yes, there was a short gap where I left the department for 10 months to complete a degree and came right back.
Now, so since getting that degree, have you been post-certified?
Yes, sir.
And then what does it mean to be post-certified?
You've been through the minimum requirements that the state of Georgia has put aside to be trained as an officer.
Now, I want to jump to November the 18th, 2021. Were you on duty that morning?
I was.
In what capacity?
We were actually answering calls for Precinct 1. They had some training as a as an entire precinct, so we were covering the road for them answering calls.
Now, when you say like responding for calls, what does that mean?
Someone calls 911, they'll dispatch us out to it. So we were.
That's why they took so long.
Our step duties, we were answering calls for service.
Now, at some point, were you dispatched to 5059 Verbena Drive in Akbar?
Yes, sir.
Is that in Cobb County?
It is.
What were you being dispatched to?
Kind of a welfare check, missing persons, possible missing persons.
Break and
there was
entry.
also there was some forced entry, so possible burglary. So it was kind of a serious call.
Now, I'm going to show you what's already been admitted into evidence. Exhibit 6. What kind of document is this?
That is a CAD report from 911.
No, what is a CAD report?
It records the first time the 911 call was put in, and then everything from that point on, address, time, who was dispatched, when they arrived, anything we say in the radio, the dispatch will add it to the call.
So does it document as soon as that call comes in, the 911 call comes in?
Yes, sir.
In this document, what time was this 911 call created?
Showing 9:34, 43 seconds.
Is that AM or PM?
AM.
And so for this incident here, is that the time that the first 911 call came in?
Pretty close to it.
LAB.
So once this phone call came in, around what time did you arrive?
Thank you so much,
It was
LAB.
close to 9:45, a couple minutes before that, maybe 9:43.
Now, when you arrived to that location, what observations did you have?
There were a couple people already at the residence, family members of Mr. and Mrs. Hicks.
Now, where did you come in contact with them?
I believe I was getting out of my car. I believe they met me in the road, right near their driveway.
Now, did you kind of get a rundown from them of what they had observed?
Yes, sir.
Now, what did you do with that information?
Realized we needed to check the perimeter. They said there was a busted window in the back of the residence, so that's where we went to.
All right. And so did you actually make your way around the house at that point?
We did cut through the side of the yard and right to the back door.
Now, when you got to the back door, what did you observe?
A window to the right of the back door. There were two back doors, one on each side of the house. On the right side of the house, there's a window to the right that was busted out.
Did you notice any glass?
A little bit of glass on the concrete. Most of the glass was inside it was like a sunroom on the floor.
Now, when you were outside of that window, could you really see into the house?
Initially, no, because there was a set of blinds.
Shelly, that's awesome.
We moved those and still couldn't see inside.
Could you hear anything from the interior of the house?
A dog barking loudly.
Could you hear a child?
Not at first. When we moved the blinds, I could hear a child's voice, a small child's voice.
So once you're in front of this window, what did you do next?
We knew we needed to get inside. We checked the doors, and they were both locked. So I decided to crack out the remaining pointy shards of the window so I could make entry.
And were you able to make an entry?
I did, yes, sir.
So once you were inside the home, kind of walk me through what you observed.
There's glass all over the floor. I looked up and I saw probably like a 2-year-old child peek around a corner. Seemed to be pretty scared. As I walked further into the living room, I saw Mr. and Mrs. Hicks deceased. I think Mrs. Hicks was on the couch and Mr. Hicks was on the floor, kind of sitting up. He had a toy on his leg. First thing I wanted to do was go check on the child.
Now, when you said that you wanted to check on the child, kind of walk me through that.
Well, he looked very young. It being about almost 10 o'clock in the morning, I figured he'd been by himself for a while. I wanted to check on him. When I spoke to him, I could tell he was soaking wet and he had blood all over his pajamas. The diaper appeared pretty full. I mean, like he has not been changed since the night before.
So once you came in contact with this child, what did you do next?
When I saw the child, I actually went and forgot to unlock the door for my partners to get in. So I went back and unlocked the door, and I went and got the child. He was in a front office room, right on a desk, and I think he's holding a set of reading glasses. Checked on him as soon as I found out he was okay. I picked him up and carried him through the front door. I had unlocked the front door, and went around and gave him to his relatives.
Now, after giving the child to his relatives, what did you do next?
Went back around to the window and met with Justin's father, and I believe it was Amber's father as well.
And, just generally, what kind of conversation were you having with the fathers?
I believe they suspected that it was going to be bad news, and I had to give them the bad news that Justin and Amber were deceased, but their grandson was okay, and I had turned them over to other relatives before talking to them.
Now, once you kind of had this conversation, what did you do next in your investigation?
At that point, we needed to clear the rest of the house and make sure that if there was a burglar inside, he was not still inside.
And, kind of for the judge, what does it mean to clear a house?
We go room for room, checking anywhere that a person could be hiding to make sure there's no one hiding inside.
And did you search the upstairs bedrooms and the sort of this home?
Yes, we did.
And for the court, can you describe kind of the state of the upstairs?
Very clean. Everything seemed to be in order. Nothing was displaced. Found items of value, handguns and rifles still in the closet, not touched.
Now, were you equipped with a body camera that morning?
I was.
And was it operating that day?
I believe so, yes, sir.
Prior to your testimony, did we meet?
We have, yes.
And were we able to go over your body camera from that evening or that morning?
Yes, sir.
And was that body camera a fair and accurate copy of the recording from your body camera that day?
Yes, sir.
At this time, the state moves the enter what's marked State's Exhibit 7 into evidence.
Any objection? State 7 is admitted.
May I call the judge?
Yes.
And for the record, we are starting this body camera at 17 minutes and 30 seconds.
Has he been barking yet? Have you heard barking? Yeah, just stand by with us. We'll get the dog. No, I did not. All right. You got a pit mix, they said?
That's the kitchen, dining room, living room, baby playroom, upstairs.
All right, we'll see. Will this lead into the house too?
Yeah, but there's 2 doors, you gotta go through that. Other than that,
He's got to go through the broken window.
418 upstairs. Okay, please. Bruno. Hey, Bruno. Hey, Bruno, what's up? Bruno. Already broken. Come on. Hey, here, Jack, baby. Here, Jacob. Call police. Jacob. Hello? Hey. Hey, keep him out. Hey, yes. Call police. Hey, baby, how are you? Okay, come here. Come here. Hey, come here. Come here. Come here. Hey, how are you? Okay, come here. Come here. Come here. Stay right there. Stay right there. I'm gonna stay with this kid real quick. Take the kid out or what? Yeah, I'm gonna make sure there's. Come here. Come here. Come here. Come here. Come here. Hey, where they at? Where's Granddad? Where's Granddad? Okay, go get Granddad for me.
What's wrong?
Who are you?
I'm his mother. The son lives here.
Okay. I need to speak to you.
He's in the back.
Okay, just hang out here for me. Guys. We got Jacob with him up here. No. I know they're both in there. No. They're both in there. What? They okay? No. They're not. Looks like they're both. No. So I don't know the. Upstairs? They're downstairs right on the couch.
You got to see?
Go back. We got a hold for now. Sergeant's on his way.
What's the like the happy shot? What?
I don't know. I looked at them. They're both laying on the sofa right there in front of the TV. They're both gone.
No. Where was the baby?
She's running around. Yeah. And I don't know what time it happened. There was a dog pig in the pool. So, yeah, we got.
Ask a favor of you. Just wait out here. Let us know what's going on. Come back and answer questions. Okay. We can't let anybody in the house. We can't let anybody. I'm retired with Texas Security. For years. I know. Go through and do something. And get y'all way back there.
The cameraman's in a catch-22. He's required to keep the camera rolling, but there's so many TVs in the room. He has nowhere to look.
I'm gonna hold on. I got the left door. You got that one? You got to hold on to your right now? I'm behind you. Clear. Coming out. We're taking the fall.
They're clearing the rest of the house right now.
Completely empty.
Completely empty.
Yep, clear.
For the record, I'm stopping States Exhibit 7 at 20 seconds. Now, officer, prior to your entry to the window in the back, were all the doors locked?
The back two doors were locked, and when we went out the front, that one was locked. I don't know about any other doors.
And really, for your entry to this house, was it that window?
I'm sorry?
For the entry for yourself, was it the window that had already been busted?
Yes, sir, it is.
Now, I want to talk about the little boy, Jacob.
Yes, sir.
We kind of see you in the video kind of grab him in that media room, but then stick out a hand. Can you go over that action?
I guess I just wanted to be less traumatizing to him and just kind of put out a hand like I would do, my kids when they were that small.
Let me ask you this way. You described Jacob as being wet.
Yes.
And on his clothing, could you see blood on him?
Yes. Pajamas were wet, and he had blood stains all over his clothes, on the front of his clothing.
Now, was the dampness to his clothing just on his bottoms, or was it on the tops as well?
It was pretty much everywhere.
Now, I want to show you some photos. Now showing you what's marked as States Exhibits 8 and 9. Do you recognize those exhibits?
Yes, sir.
And how do you recognize them?
They're taken from my body camera footage.
The body camera footage you just watched?
Yes, sir.
At this time, the state moves to enter what's marked as State's Exhibit 8 and 9 into evidence.
Any objection? States 8 and 9 are admitted.
May I call the judge?
Yes.
I'm now showing you what's marked as State's Exhibit 8. Now, where is this screenshot taken?
That's in the living room, so the window is going to be kind of behind me to the left, and the front door is straight ahead. Bathroom's on the right, and Jacob's in like a little office area at the front of the house.
Now, into the right of Exhibit 8, kind of right here, is this Jacob standing right here?
It is.
Is this really one of the first times seeing Jacob once in the house?
Yes.
Now, I'm going to show you what's marked as State's Exhibit 9. Who is this that we see here?
That's Jacob.
And what is Jacob holding?
A set of reading glasses, or eyeglasses.
Now, it might be hard to see, but I'm going to zoom in a little bit. Now, we kind of see some smudging on the front of the pajamas here. Is that what you remember to be blood?
Yes.
And at this point, were you worried about getting blood on your hands?
Yes.
And is that why you kind of waited to the last second to pick him up and take him to his family?
Combination of the blood and being wet.
Now, once you gave Jacob back to the family and you cleared the house, did you have any additional involvement that's really in the case?
Not at this point, no, sir. We stood by for crime against persons detectives to arrive.
Thank you, officer.
Thank you.
Thank you. Attorney Barry, you may proceed with questions.
Good morning, Officer Brent.
Good morning, sir. How are you?
Just a few questions I need to ask you. Were you the first officer on the scene that appeared with the body cam?
Yes, sir, I was.
And when you walk around to the back of the door, you noticed that the window was broken.
Correct.
Okay, and the shade was down?
Yes.
Were all the other shades down on the windows?
I don't remember. I remember that one. That's the only one I remember.
Okay. And we saw in the body cam where you took your baton and knocked some more of the glass out.
Yes, sir.
So that you could get through. Was there a good bit of glass still in the window?
I would say the majority of it was already broken. It was just some shards around the edges that I broke.
Would it have been difficult for somebody, say, your size, to get in that window with the glass configuration the way it was without breaking out some more of it?
With his duty belt.
I don't think it would be very difficult in my configuration with the uniform on. I think just regular clothes, you would be able to get in there.
Okay. And if you had a coat on or something like that, would it have been more difficult?
I don't know. It would be difficult in my uniform with the vest, and you're kind of top heavy. It's kind of awkward.
Okay. Was there any of the glass that you saw that appeared to have any blood on it at all?
I didn't. I wasn't looking for that. No, sir.
And what you can tell,
he's a skinny guy.
You know, when you break a window, the glass usually goes into the room.
Yes.
So this would appear as though it was broken from the outside in rather than from the inside out.
Yes, sir.
Fair to say?
Yes.
You told us that the dog Bruno, when he first came to the window, was barking pretty loud, and we could hear the dog barking the entire time you were there.
Yes, sir.
And did it appear as though the dog was upset because somebody was in the house that you didn't know?
Initially, yes, sir. As soon as I kind of spoke to the dog, he calmed down.
Okay. And I think you indicated that the front door was locked and the back door was locked, but you're not real sure about all the other doors in the house.
That's correct. I didn't check any other doors. Those are the three that I had experience with.
Okay. And we saw that the TV was on.
Yes.
You came in the room. I also noticed going up the stairs was the TV clicker. Do you remember seeing that?
I remember seeing something on the stairs. I don't remember what it was, but there was something on the stairs.
Okay. Do you remember how many stairs up that clicker would have been?
Probably halfway up.
Okay. Did you see any other TV clickers down around the couch area?
No, but I wasn't looking for stuff like that.
Okay.
I didn't.
That would have been the detective that...
They did probably the fine-tooth comb of the scene.
Where was the child's bedroom, if you remember?
If I'm not mistaken, it's up the stairs to the right.
Okay. And I didn't see any shell casings in your video. You were not looking for those either.
I didn't see any. My focus was on the kid when I first got in there. I wasn't looking for. I didn't look for any shell casings.
Okay. When you came to the back door where the window was broken, did you see any item that would have broken the window, like a rock or stick or anything that may have been used to break that window out?
I don't recall anything, no, sir.
All right. Thank you.
Thank you. Is there any redirect?
Yes,
May this witness be excused?
Yes, sir.
And released from subpoena?
Yes, sir.
Okay, thank you. Thank you. State, may call your next witness.
Statement calls Sergeant Mark Gaskew.
Watch your step on the way down there. Are they washing the microphone between witnesses?
You do solemnly swear or affirm the testimony you're about to give the court on the issue now pending shall be the truth, the whole truth, nothing but the truth, and so help you God.
I swear.
Please have a seat for me. Once seated, if you would please state and spell your true and correct legal name for the record.
Yes, ma'am. Sergeant Mark Gaskew, that's MarkGasque, I work for the Cobb County Police Department.
Wonderful. How long have you been a sergeant for Cobb County Police?
10 years.
And how many years total have you been with Cobb County Police?
19.
Are you post-certified?
I am.
I want to jump right into November 18th of 2021. Where were you assigned at that point in time as a sergeant?
I was a sergeant in our Major Crimes Homicide Division.
And what are the job responsibilities of a sergeant with major crimes?
You triage the calls that come in. Obviously, you delegate the case assignments, and then obviously you monitor the investigation as it goes through.
Are you still a detective as a sergeant with major crimes?
I am, yes, ma'am.
So you do detective work as well as supervising?
I do.
Okay. And as part of the supervision responsibilities you have, does that include crime scene technicians?
Yes, when I was in homicide, the crime scene technicians fall underneath the sergeants of the unit.
Were you working back on November 18th of 2021?
I was.
All right, and at that point in time, do you recall what your hours were just in terms of days versus evenings?
I worked the day shift.
Now, was that a weekday?
It was.
So were you actually in the office on November 18th of 2021?
Yes, I was.
Did you get a call regarding 5059 Verbena Drive?
Yeah, I believe it was just before 10 a.m. that morning.
Is that here in Cobb County?
It is.
All right, what did you do upon receiving notification of a call coming from 5059 Verbena Drive?
So when you receive a call like that, and obviously this one was involving 2 deaths, so it's a little bit larger level response, you begin delegating. First you assign who's going to be your primary detective, who's going to be his secondary, which crime scene technicians are going to go, who's typing search warrants. You just start laying out a plan.
How many detectives worked under you approximately back in 2021?
On day shift, I believe we were between 10 and 12 on this.
And typically are really all 10 to 12 of you working on a case at the same time?
Yes.
In this particular case, who was assigned to the lead agent?
Detective Standard.
Did you actually respond to the scene that day?
I did.
All right, and prior to taking the stand today, did you and I have the opportunity to go through crime scene photos?
Yes, we did.
And was that taken by someone you supervised as the crime scene technician?
Correct. I was the crime scene supervisor that day.
Very good. And so prior to testifying, did you look at State's Exhibits 10 through 305?
Yes.
Okay, and all of those have previously been shown to the defense counsel. Are all of those photos true and accurate photographs of the scene as you observed it on November 18th of 2021?
They are.
Statements to tender State's Exhibit 10 through 305.
Any objection?
No objection.
States 10 through 305 are admitted.
Very good. And I begin publishing? Yes. All right, we won't go through every single one of these, but there's your little routine here. Yeah.
Some of these are duplicates,
Okay, thank you.
Similar.
All right, and so noted for the record.
All right, so starting here with State's Exhibit 10, what is being documented in State's 10?
This is the mailbox to show the physical address of the home.
State's Exhibit 12 here What is this walkway we're looking at in State 12?
This is the sidewalk leading from the driveway we were just looking at around to the front door of the home.
Now we can see here, kind of in the Pine Straw area, ADT security. Was there an ADT security system?
Yes, there was, and it was actively monitored, an active account.
And was that like a video surveillance system or just an alarm system?
Just an alarm system.
Not a really good advertisement.
Exhibit 13, what are we looking at here?
This is the front door of the home.
State's Exhibit 15, what am I pointing out in State's Exhibit 15 on the door frame?
That's a Nest doorbell camera.
Now, were you able to determine whether there was any active storage or footage from that front doorbell camera?
We were, and there was not. It was a live-only viewing subscription, so no stored data.
State's Exhibit 17, what am I pointing at in State's Exhibit 17?
That's a newspaper beside the mailbox.
I'm looking at State's 19 here. Did it have the date of that newspaper?
Correct. Thursday, November 18th, so the morning we were out there.
So obviously not been picked up.
Correct.
State's Exhibit 20, what type of truck do we see in the driveway?
That's a Ford F-150.
Is it customary to take kind of 360-degree angle of vehicles that are in or within county seats?
Yes, it is.
State's Exhibit 22, is that one of those photographs?
Correct, of the same truck.
State's 23.
And that would be the other side of the truck.
Then State's 24.
And the rear of the truck.
All right, was there any damage that you noted to this vehicle?
No.
State's Exhibit 25 here, what are we looking at in State's 25?
So this would be the garage doors directly behind that truck, and then a side door to the home just past that flag.
State's Exhibit 27.
Yep, and we're continuing down that sidewalk just past the garage doors to that side door.
The side door, is that what I'm pointing at on the right-hand side?
Yes.
State's Exhibit 28 here. Is this a kind of straight-on view of that side door?
Correct, as if we're continuing down the sidewalk.
Up in this corner near that side door, is there another sort of camera?
Yes, I believe that was another Nest camera, and then also live view only, so no paid subscription.
Now, State's Exhibit 29 here, do you recall whether this door was locked or unlocked?
It was locked, yes.
And State's Exhibit 30, what was to the left side of that door?
A delivered package.
State's Exhibit 32, what side of the house are we on now?
I believe you'd be on the south side of the house, so this is continuing past the door we were at, to the side of the driveway.
And what do we see up in the corner of the house?
That's a motion floodlight.
State's Exhibit 33.
That's continuing around the side of the home we were just looking at, so now we're in the backyard.
State's Exhibit 34.
Again, continuing around toward the back door of the home, the patio.
State's Exhibit 35.
And that would be the back patio, so we're looking straight at the rear of the home.
State's Exhibit 36.
That's a sunroom, or I believe it was the playroom for Jacob, and where the Christmas tree was inside that room.
Now, is it customary to kind of continue taking photos all the way around the house?
It is, yes, ma'am.
So State's Exhibit 37, are we making our way further around the house?
Correct.
State's Exhibit 39 is continuing to walk the perimeter of the home.
Yes, ma'am.
And State's Exhibit 41, where is this vantage point?
So now we would be on the north side of the home, looking toward the front of the home there.
Now we're going to focus on that kind of rear patio area. Was there any other damage on the exterior of this home, with the exception that of the window we're about to focus on?
No.
Now looking at State's Exhibit 42 here, did this door go into the residence?
It went into a sunroom area.
Was that locked?
It was locked, yes.
Looking at State's 43, Is there another door kind of directly across from the sunroom door?
Yes, going into the child's playroom area.
And was that door locked?
Yes, it was locked.
And was there any damage that you all observed to either of those doors, like pry marks or anything, to indicate there had been attempted entry even at those doors?
No, there was not.
Looking now at State's Exhibit 44, where was kind of the focus of you all's investigation?
Okay, yeah, the one point of entry that we could find was the broken window right there to the right of that rear patio door.
Now, at the time that the crime scene, that you're supervising and going through the scene, as well as documenting the scene with your crime scene technician, have law enforcement already made entry?
Yes, they have. I believe they cleared the home multiple times.
And so, with some of the glass that's broken out actually from law enforcement?
Yes.
State's Exhibit 47. What's being documented in State's Exhibit 47?
It's a little closer up, obviously, of the window and of that Adirondack chair that's sitting there, and some of the glass shards on the ground.
State's Exhibit 48.
More of the shattered glass from the window.
State's Exhibit 49.
And then continuing just to zoom in on the glass.
Looking at State's Exhibit 53 here, what side of the Adirondack are we on?
We're on the back side of it now, so our back would be to the home.
All right, and just for reference purposes, looking at that kind of white scratch, looking at State's 54, what are we looking at there?
That's a shard of glass from the broken window.
And is that kind of a zoom in from the previous exhibit of State's 53?
It is.
Did you see any sort of like marking or pattern on some of the glass?
Now we have no audio. Let's see what they do with it.
State's Exhibit 55.
Oh, they fixed it.
Yeah, continuing now, we've zoomed out from that glass just to show that broken window from a different angle.
Now going to State's Exhibit 57 there. At the time that you all were documenting this, is this how the blinds were kind of like propped on that cat?
Yes, that's how they were when we arrived.
When you say we, you mean like detectives?
Detectives, yes, sorry. The crime scene unit.
Might be able to take that ring out now. Doesn't oscillate.
Zooming in, obviously on the glass, you can see here that's a double pane window, which explains the large amount of glass that we're looking at, and then showing some of the shattered glass inside as well.
State's Exhibit 60 here, what are we looking at?
Now we're inside the home, inside Jacob's playroom, looking back out that broken window.
And what do we have here on the left-hand side?
We have a Christmas tree.
State's Exhibit 61. Is there glass on top of Jacob's little bench there?
Yes, there is.
State's Exhibit 63. What is kind of the vantage point here?
So this is a lower shot with the crime scene technician kind of squatting down, looking back out the window.
State's Exhibit 64.
That's a large amount of glass shards just inside the window on the floor.
State's Exhibit 66.
Still a little buzz, but it's better
what
than
door are we looking at here in the right upper corner?
So when we were looking at the exterior photos, when you looked at the window, that's the door that was to the left of it. So going into the playroom there, but that's an exterior door.
Is there any glass in front of that door?
Yes, we had glass shards coming in from the window there through the playroom. And that door was locked as well.
State's Exhibit 70.
Now we're looking at that door. So we've zoomed out. You see Jacob's bench right there to the left. So that's the exterior door to the patio.
Looking at State 72 here, what was on that patio door?
It's a child's lock, which I believe we saw on every exterior door of the home.
State's Exhibit 73.
Now this is the front door of the residence.
All right, State's Exhibit 76. What do we see in State's Exhibit 76?
Okay, so now I'm standing, this is back to that broken window, so the Christmas tree would be off to the right there and looking into the living room. Obviously, we have a child's gate that appeared that would have been closing off the playroom from the living room that was knocked over, and some toys lying on top of it, and a cell phone on top of it.
What do we see in this area in front of the fireplace?
And so another baby gate that appeared as if it had been placed around the fireplace but had been moved.
State's Exhibit 77. You mentioned some toys and phones. Is that depicted in State 77 on top of the baby gate?
Correct, it is.
In State 78, we'll circle back to this, but the black item here on State 78.
Yeah, we learned that to be Justin's cell phone.
So that was like an actual real cell phone, not some sort of toy.
Correct.
State's Exhibit 79. What do we see in State 79?
So now we're looking into the living room from the playroom toward the fireplace and that baby gate.
State's Exhibit 80.
Now we're looking at the couch, so just to the left of the fireplace.
DMB, welcome. Good to have you here.
State's Exhibit 221.
Now we're looking at Justin and Amber Hicks deceased in the living room. If you look directly behind them is the illuminated Christmas tree, and just to the right of that would be the window, the broken window.
And so from where Amber is there on the couch, without moving, would she have been able to see the window?
It does not appear so, no. It should be back behind that wall, tucked in there. Correct, right back there.
34 months. OG. DMB, congratulations. Good to have you here. You did not manage to fly under the radar. Congratulations, most OGest of OGs.
Exhibit 222.
This is Justin Hicks.
State's Exhibit 223.
It's another angle of Justin.
And what is it that was on Justin's lap there?
It's a child's toy airplane.
Now, from where, back up just a minute here. Going back to State's 221 here, had Justin been standing kind of relatively where his feet would have been, or are in this picture in State's 221, would you then have been able to have some vantage point of the window in the playroom?
Yes, if you'd have looked off to his right shoulder, you'd have to turn to look to his right shoulder.
Now going back to State's 223 there, was that like a paper airplane or an actual like plastic?
No, that's a plastic acrylic child's airplane that obviously had been placed there after Justin had fallen.
And why is it that it would have been placed there after Justin had fallen?
I don't see a way it could have stayed where it is if he'd have been standing up. It was not attached to him.
State's Exhibit 224 here, what are we looking at?
That's a closer up look and looking at the amount of blood that's on Justin.
State's Exhibit 225.
Now we're looking at Justin's hands.
State's 226.
This would be Justin's left leg, and then obviously just to the side of there you see a Fisher-Price fire truck.
There's some other pictures of that we'll circle back to. Now looking at States, so going from States 226 here to States 227, what is it that y'all now zoomed into?
That's a broken shard of glass just off the rug there in the living room.
States 228. What is this item that's on the rug kind of in front of the ottoman?
It's a child's train whistle. That you blow in mimics the sound of a train.
Zooming in there, States 229, what was located near that child's train whistle?
We have some more broken glass.
States 230, is that a zoom in of that same piece of glass?
It is.
States 231. What are we looking at here?
Now this would be standing obviously on the other side of Justin, standing over him. Shows how that plane is lying there lightly on his shorts. You can see the fire truck and another toy at his feet.
I'm looking at states 232 here, as well as states 233. What have y'all zoomed in on in those images?
What appeared to be a fresh cut on the inside of his thigh.
Going back to states 229 here, could you tell whether that was possibly, and I know that doesn't portray it well, and I'll know, but whether there was any possible blood stains near some of the shards of glass?
Possible. Obviously, we when you're working at a scene like that, we swab and process everything that we think could possibly appear to be blood.
States Exhibit 234, what are we looking at here?
Now again, we've kind of moved a little bit more over Justin, showing the back of his head and the right side of his body now.
And what is behind his head?
We have a blood stain on the couch.
States 235, what do we see here kind of in the middle of the photograph?
Another blood stain on Justin's shirt.
In States Exhibit 236, was there any sort of defect that was noted on
Correct.
the shirt?
Yeah, in the middle or in the area of that blood stain is some sort of hole.
States Exhibit 237, did you see any other defects on his clothing?
Yes, right there on his right arm, right shoulder area.
States Exhibit 238, is that a zoom in of that same shoulder area?
It is.
Looking at States 240, did you all also zoom into the area behind his head?
We did.
I think they only tendered up to 235.
What is the 305?
305.
10 to 235.
305.
305.
10 to 305 is what the court admitted. Yes.
I thought they tendered only up to number 35, and no, it's 305 on the images. That's why it's important to hear.
243 here. Who is kind of the focus of your attention in these next several photos?
This is Amber Hicks.
States 244. Can you describe kind of the positioning of her body here?
She's lying, her body's on the couch, her feet and her legs are on an movable ottoman. She's partially covered by the blanket there. And obviously you can see her arms down by her side.
And what is this orange object that we can see by her legs?
It's a small ball, a child's toy. And then we also have the monster truck on the other side of her leg.
States 246, is that kind of zooming in on both the ball as well as the monster truck?
It is.
States Exhibit 247 here.
Now we're standing at Amber's feet looking toward her head.
And on the left side, kind of underneath the blanket, what is that?
That would be her other leg.
Is her leg kind of tucked under that blanket?
It is.
States 248, what are we looking at here?
Again, now we're moving more to the left here. We can still see the ball, the monster truck. You can see the defect in Amber's right arm right there and the glasses down off of her face.
States Exhibit 250, how close was that ball to her hand?
Inches. Yeah, maybe 6 inches, maybe.
States Exhibit 251, did she have glasses?
She did.
States 252, is that kind of zooming in on her glasses?
It is, yeah. They were obviously not sitting naturally on her face how she would be wearing them. It appeared they'd either been pulled down from her face or fallen from her face.
When you say pulled down, like from Jake out? Or?
Yes, from Jake, that was my assumption. With the amount of toys that was on her, that was my assumption.
This poor kid kept bringing toys to his dead parents, trying to wake him up.
Looking at States 254 here, what are we looking at?
12 hours.
States 254.
That's a defect from a projectile in Amber's right arm.
States 255, what was being documented in States 255?
The blood on the couch coming from Amber.
Now, being there in person, looking at States 256, could you tell whether there was any like coagulated blood or kind of thicker amounts of blood?
Yes, you could. That's typically what we would see from coming from someone's head.
And that was documented in 256.
It is.
States 258, what vantage point is States 258 taken from?
This is standing in the kitchen, looking out, or with your back to the kitchen, looking out over the couch toward the fireplace.
States Exhibit 260, that kind of a better image of some of that coagulated blood.
It is. Again, this is standing with your back to the kitchen, looking over the couch.
States Exhibit 265. Could you tell whether there was any defects in her shirt?
Yes, there is one. Obviously, a large amount of blood. That's in her abdomen area.
Looking at States 270, what items were close to Amber's hand from the couch?
Her cell phone is there. Obviously, there's a water cup, and then we see a baby monitor on the other side of the pillow.
Was that a video baby monitor?
It was.
Okay. Now, was it the kind that you have like a SIM card or some sort of subscription that you can go back on, or just
No, just a live feed.
Now, is it customary, again, when documenting the scene, to start moving the decedent so that you can better photograph some of the evidence?
It is, yes, ma'am.
Now, is that process also documented?
It is.
All right, looking at States 273 here, explain what we're looking at in States 273.
Okay, so we're looking at, obviously, this is Amber's body with her shirt pulled up. We still see the defect there in her right arm. You see an abrasion on her stomach right there, and then a projectile is lying between her right arm and her right hip.
States 274, is that a close-up of that projectile?
It is.
And was that projectile collected?
It was.
I want to show you what I've already shown defense counsel, States Exhibit 600. Do you recognize States 600?
Yes, I do.
Okay, how is it that you recognize States 600?
It is marked as the projectile collected on couch next to Amber Hicks.
And is that what we see in the image on the screen, which is States Exhibit 274?
Yes.
State moves to tender States Exhibit 600 into evidence.
Any objection? State 600 is admitted.
States Exhibit 275, what are you all starting to kind of focus on?
Now we're showing, obviously, the area around Amber there, showing the baby monitor, the monster truck, toys.
States Exhibit 277. Is that a zoom in of that baby monitor?
It is.
Now looking at States 284 here, where are we standing?
Now we're standing just at the feet of Amber inside the couch, the L-shaped couch there, looking back toward the playroom, which is where the entry point is.
Okay. And at this point, had some of the items been marked?
They have been, yes.
Okay. In particular, what was States Exhibit, I'm sorry, not States Exhibit, the crime scene Exhibit 1, or which had the number 1 marker?
Justin Hicks' cell phone.
Looking at States 289 here, did you all kind of illuminate the screen so you could photograph any notifications?
Yes, we did.
And is that what we see on States Exhibit 289?
It is, yes.
And so just to point out some of these things, the very top one here where we can see, well, first of all, what is the timestamp at which y'all are documenting the illuminated cell phone?
That's 11:51 a.m. on Thursday, November 18th.
And so the very first notification here where you can see your camera spotted someone, is that the front doorbell camera that we previously saw in photos?
Yes, the Nest camera.
And again, was there any video you were able to recover in terms of saved video footage?
No, we were not.
And then similarly, where there's 32 minutes ago, person seen zone 1 side door camera, again, was that any sort of footage that you were able to actually retrieve saved images or videos from?
No footage was returned to us.
And based on the notifications and background, is that how you were able to determine this was Justin Hicks' cell phone?
Yes.
And this cell phone that we see in States 289 here, was that collected?
It was.
Let me show you States Exhibit 606. Do you recognize State 606?
I do. It says it's a gray Apple iPhone belonging to Justin Hicks.
Is that from marker 1 in the crime scene photos that we're going through?
It is, yes.
Very good. Is that his actual cell phone that you all collected from the scene?
Yes, it is.
State, and there's a biohazard sticker on here. What is that for?
Some sort of bodily fluid. It appeared to be blood on the phone.
State moves to tender State's Exhibit 606 into evidence.
Any objection? State 606 is admitted.
And did it appear, based on you physically being present at the scene and making the observations that you did, that Justin Hicks would have been able to get his phone to this location with possible blood on it?
No, it did not. Our assumption, based off the way the house looked, is that Jacob most likely moved the phone.
State's Exhibit 292 here. What area of the house are we now focusing on?
This is the playroom just to the left of the Christmas tree. So again, we're in the same room where the broken window was.
State's Exhibit 293. What do we see?
We see a pretty decent amount of children's toys spread out on the floor and a trampoline as well.
Throughout the rest of the home, did you see this volume of toys or mess?
No, this home is very clean, very orderly. Obviously, this area here and then where the toys had been moved into the living room where Justin and Amber were the only areas of the home that appeared to not be in order.
And based on how the toys appeared and things being dumped out, did it appear Jacob had been in this room?
Yes, to any of us that have had children, it appeared as if a child had been playing unsupervised.
Looking now at State's Exhibit 296, what did you all find underneath that trampoline?
There's a shell casing underneath it.
State's 297, is that a zoom in of that same shell casing?
Yes, it is.
We're not seeing these pictures because they keep including the body in the angles. So we're seeing the crime scene, which the camera's trying to be careful about.
I'm going to circle back to those in just a minute. Now, State's Exhibit 300. Was there additional kind of mess or disarray behind the trampoline?
Yeah, it looked as if possibly these storage cubes had been pulled out from that cubby area and then the toys dumped on the floor there and onto the trampoline.
State's Exhibit 301. Is that kind of a better image?
It is correct. We're standing over the trampoline now looking at the pile of toys.
And on top of the trampoline, this white object, what is that?
Another one of those storage cubes. It's just collapsed.
And is it underneath this trampoline that we just saw that casing?
Yes, it is.
State's Exhibit 302. What had Justin and Amber put up in their home in the playroom?
A fairly large Christmas tree.
And State's Exhibit, well, you can see it in State's Exhibit 302. Was that lit? I mean, did they have lights on?
Yes, the lights were on. It
And were
appeared as if they were twinkling.
So not the steady lights. But
Correct.
Kind of twinkling lights. Okay. And were those on when you all first arrived?
They were, yes, ma'am.
Now I want to make our way back towards the living room area, looking at States 81. And I know we've gone out of order here, but it made the most sense. So looking at States 81, what are we now looking at?
Okay, this is, we would be standing with our back to the couch where Justin and Amber were lying, looking at the fireplace.
And you had previously mentioned this baby gate. Was there any ability for that baby gate to be actually like locked into the fireplace, or was it just one that you kind of placed in front?
It appeared it had just been placed there. I know there are hooks on the gate, but I don't recall any mounting area for it, any anchors.
The way that baby gate was when you all arrived, did it appear to be really protecting anything?
No, it had been moved.
States Exhibit 82 here.
We're looking at obviously the built-in cabinetry to the right of the television.
Is this on the other side, States 83?
Correct, that's the built-ins on the left of the television.
Now looking at States 85, were there any toys around the area of the fireplace?
Yes, you had toys obviously inside the baby gate area and outside the baby gate area.
In States Exhibit 84, you actually see some additional toys outside the baby gate area.
You do, yes, ma'am.
States Exhibit 86, what is this blue object within the baby gate?
It's one of those collapsible tunnels that like a toddler can crawl through.
Did that appear kind of out of place in that location?
It did, yes, ma'am.
just past the little tunnel states 87. What else was there?
We have a shard of glass laying right there, and then a projectile just to the right of it.
Based on the appearance of the point of entry, would it really have been possible for a shard of glass of this size to land in this particular area from within the living room?
No, that glass had to be carried there in one way or another.
States 89. This kind of an attempted zoom into both the shard of glass and the projectile.
Yes, it is.
I know it's kind of difficult to see. Let me show you States Exhibit 90. Or better yet, let's look at States 91. States Exhibit 91.
Yes, that's the projectile inside the baby gate, lying just to the right of that shard of glass that we saw.
States Exhibit 601. Do you recognize States Exhibit 601?
I do, yes. It says it's a projectile collected from the floor in the living room.
Is that what's seen in States Exhibit 91?
Yes, ma'am, it is.
State moves to tender State 601 into evidence.
Any objection? State 601 is admitted.
States Exhibit 92. What are we looking at in States 92?
This is a dog bed just outside that baby gate area. So this would be to the left of the fireplace.
Did y'all move that dog bed at all?
We did.
Okay, so looking at States 92, is that before y'all had touched it or manipulated it?
Correct. That's how it was when we entered the home.
States Exhibit 93, have y'all now moved it at this point?
We have.
Right. States Exhibit 94, what is it that was located behind the dog bed?
That's another spent shell casing.
States Exhibit 95, is that a zoom into that same case?
Yes, it is.
Now looking at States 305, what area of the house are we now standing?
So we're now standing. We had moved the couch and the rug at this point. So if you're looking around the right-hand side, we'll be going toward the front door of the home. And that's that Fisher-Price truck that we had seen lying just to the left of Justin originally.
When you say lying to the left of Justin originally, was that more so in the doorway?
It was, yes. We had to move it as well.
And what is the purpose of moving items such as something as big as a couch and a rug during the crime scene processing?
But we're looking for any sort of evidence. Primarily, at this point, we were attempting to find all the shell casings and projectiles that we could.
And did y'all go through kind of tedious and strenuous search efforts to find any additional casings or projectiles?
Yes, I believe we were on the scene until after midnight the following day. So quite some time attempting to find all the shell casings and projectiles.
Now, we can see here on the floor near the baseboard kind of two different markers. Did you all find anything of interest in that area?
Yes, there was fresh damage to the baseboard. Possibly a defect is why we photographed it.
Looking at States 96, is that starting to zoom in on that area?
It is.
And is it customary whenever photographs are taken by one of your crime scene technicians to kind of zoom in on certain areas so that you don't lose your bearings?
Correct.
Looking at States 97, is this the most zoomed in image of that damage?
Yes, it is. You see some damage to the floor and then obviously to what appeared to be a freshly painted baseboard.
Looking at States 98, which area are we now focused exclusively on?
Now we're looking at the baseboard.
And then States 99.
And that's the flooring just in front of it.
States 100 might be a little bit better lighting. What was noted on the floor?
It's an abrasion or a friction mark of some sort. Our thought process is a projectile could have skipped off the floor and hit the baseboard there.
And did those two markings, they're seen in States 97, relatively align with one another?
They did.
Now going back to States Exhibit 305, did you find any projectile in that area at all?
No, we did not.
Can I have the terms of approach for this moment?
Yes.
I think the judge is going to call an audible for lunch. Defendant has sort of kept that same demeanor.
All right, I think this will be appropriate time for us to take the lunch break. We'll be back at 1:30 and ready to begin. And just to remind Sergeant Gaskew, I understand you know this, but just a reminder that not to discuss any of your testimony. Obviously, you can discuss it with the attorneys, but not to discuss it with anyone else.
Yes, ma'am.
Great. Thank you. You all have a safe and enjoyable lunch. We'll see everyone at 1:30.
All right, as they go to lunch, and there's nothing for the jury to do because there is no jury, we're going to go right here and rest our ears for a little bit. We're going to go to lunch as well. Now, I realize she said they're coming back right now, which means if we take a half-hour lunch, we'll be half an hour behind, but we'll be catching up quite quickly. Do we know what his defense is? I don't know what his defense is. We know there's just no motive. There's just, something. There's some speculation that it was possibly a mistaken identity, retribution type thing. But really, this is one of those senseless crimes, and it's heartbreaking. Especially anyone who's had children and realize the impact. Realize what went on in that house for the 12 hours after the murder with that poor child. Hopefully. You hope he forgets, and that's a terrible thing to say, but you hope he forgets about what happened there, because that's just not a scene that you'd want, stuck in your mind growing up. Obviously, he's got great family support, so we're gonna take a break, a lunch break, which is like a brunch break, but different. Let's see. Going to be, let's see, we need to get the case right here. Georgia V. Hey, Mrs. R.A., how are you doing?
Good, how are you?
Great. Do you need me?
Just your phone.
Just my phone. Won't say anything. Day 1, part 2. So we are going to be a tiny bit behind, but we should be caught up by the end of the day today. That's my intent anyway.
I have a question, chat. Side with me on this, okay?
Hang on. You want to talk in the mic? Okay, there we go.
I was already talking to the mic, but it was off.
So say it again.
I have a question, you guys. I'm sorry. What is the mood here? Is everybody sad?
It's a pretty heavy case.
Oh, I'm sorry.
Parents
Can you
murdered
all
2-year-olds.
No.
Oh, okay.
Change your mood. Be happy with me. Life is good. Here's the thing. I have a question about the thumbnail. Do you guys think that Scott's face should feature more prominently? Like half of the thumbnail should be Scott's face so that you can just skim through and be like, that's Scott, that's Recovery Addict, that's the one I want. Say yes. Say yes if you want to be happy. Yeah, see, I see one yes. Let's go with that.
Of course they're going to say yes. You asked the question. I have to say yes when you ask the question. All right.
Look at all those yeses.
We're going to be coming back. You'll recognize the thumbnail because my face isn't on it.
Says yes, does no.
Hang on. I said we're coming back 3 minutes ago, and that doesn't work. So hang on. We're going to play some music. I can do that because that gets us closer to lunch. We're only taking a half-hour break. Is that fair? When we come back, we'll be half an hour behind, but we'll get caught up quickly. We'll also skip the breaks. So by the end of today, we should be with the rest of the world on this one. It's a tough one. Man, is it a tough one.
Okay, I'm totally changing the mood again. Do you guys want to hear something really exciting and fun?
You can't hear the music, can you? Go ahead. Okay.
Sorry.
Go ahead. I'll turn you up and turn the music down.
This is exciting for you guys. It's less exciting for my budget, but I'm going to go buy just insane amounts of things that go inside Christmas goodies that I'm going to make so many cool
ingredients.
Ingredients.
Yeah.
Well, not ingredients though. It's like here's this candy bar, chop it up. Here's this candy cane, bust it up and stick it on top of things. So it's not really an ingredient, but they're
ingredients. They're toppings.
It's going to be amazing. I'm really
Why?
looking forward to it. What? Because we're going to give them away, and people will love us because we give them diabetes on a plate.
We do. Luckily, people in our neighborhood. Sorry, we're not going beyond that, but we are going to.
Yeah, sorry to all of you guys.
Growing up, my mom made like hundreds. I kid you not. I'm not joking. Hundreds of dozens of cookies.
Yeah, I'm not doing that.
We'd go Christmas caroling. We scale it down a little bit, but
a ton. But it's still going to be fun.
It's lunchtime. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe. We'll go live again at 2 o'clock. So we got 25 minutes. Eat fast. We'll be back in just a little bit. We're not mailing them out, no. Sorry, the cookies don't travel well. They just don't. You can barely carry them.
The chocolate in them would not be awesome by the time
Plus,
you
the mailman would
them.
steal them. You'd never see it. So, all right, we're going to see you guys right after the break. Have a good one. Be good to each other. Bye-bye.